Come to order, please. Good morning. Welcome, colleagues, invited guests, members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. We're continuing our pre-study on Bill C-36, an act to amend the Criminal Code in response to the Supreme Court of Canada decision in Attorney General of Canada v. Bedford, and to make consequential amendments to other acts. In 2007, a group of sex workers launched a court challenge to the constitutionality of 3 provisions in the Criminal Code relating to prostitution. The Supreme Court of Canada invalidated these 3 provisions in December 2013 and gave Parliament 1 year to respond. Bill C-36 was introduced in the House of Commons in June 2014 in response to the court's decision. This is our committee's 3rd meeting on this subject. And members, please welcome our first panel of witnesses, Vancouver Rape Relief and Women's Shelter Representative Kira Smith-Tagg, who is a frontline anti-violence worker, and from the Canadian Association of Sexual Assault Senators, Lisa Stacey, who is a representative of the organization, Michelle Levelier, who is a member from Gatineau, and the final witness, Chris Bruckert, who's a professor at the Department of Criminology in the University of Ottawa. Thank you all for being here. And I believe, Ms. Smith-Tagg, you have the honors of having the opening statement. Please proceed.
Thank you. Good morning. My name is Kira Smith-Tagg, and I'm a frontline anti-violence worker at Vancouver Rape Relief and Women's Shelter. Vancouver Rape Relief is Canada's oldest rape crisis centre. Founded in 1973, Rape Relief runs a 24-hour rape crisis line and a transition house for battered women and their children fleeing violent men. Rape Relief is a collective of women of varying age and class, many of them women of colour and Aboriginal women. Our collective, both historically and presently, includes women who have exited the sex industry. Our 40 years of frontline work informs our understanding of prostitution as a form of male violence against women, alongside wife battery, incest, sexual harassment, and rape. Our analysis of the similarities between these various attacks is not an abstract theory. It is derived from and rooted in our frontline work. The work of answering call after call from women who have been beaten, raped, prostituted, incested, and sexually harassed. There are only so many calls you can take until you can no longer ignore the fact that the biggest risk to women's safety and security is men's violence. As a collective of women fighting to end this crisis and achieve women's equality, we have the privilege and the responsibility of working with each other and our callers to resist and fight against that violence from both the individual men, but also from the systematic oppression we experience as women living in a male-dominated world. The sex industry relies on women's subordination in order to flourish. This is obvious in the gendered nature of it. The majority of those sold in prostitution are women and girls, and almost all buyers, sellers, and traffickers are men. This is not a coincidence. We live in a society where men have more power than women, socially, politically, and economically. This is why we are in support of Bill C-36, which recognizes this stark power imbalance between the sexes and how those implications are lived out in women's lives. We know the demand by men in Canada for paid sex increases sex trafficking both domestically and internationally. The racist demand that fetishizes women of color and Aboriginal women fuels and guides where a supply of women is needed across the country. From where we are in Vancouver, some of the most obvious examples are Asian women filling the massage parlors and the overrepresentation of Aboriginal women and girls on the streets in street-level prostitution, specifically on the downtown east side of Vancouver. We think that by criminalizing pimps, johns, and traffickers, it sends a clear message that women's lives are worth more than the men's rights to access and control us. We are also in support of the recognition of the power and profit of advertisers in the industry, and agree that they should be criminalized for their exploitative behavior as well. The debate that this is about protecting the sex trade as an empowering and lucrative job choice is an individualistic argument that privileges a few women's experiences over the collective well-being of women. We know from the majority of women we work with in prostitution that they entered as children and teenagers and overwhelmingly had experienced childhood sexual abuse before entering. They tell us that they were poor, desperate to survive, to feed their kids, pay their rent, and more often than not, were forced or pressured from a boyfriend or husband to sell themselves. We reject that a model of legalization or full decriminalization of the sex industry will ensure women's safety and equality. We also reject that the responsibility to screen men for potential violence to be put on women. It privatizes our safety and security and reduces it to a woman's ability to detect if a man may or may not be violent, which we know is impossible to tell. In Vancouver, Robert Pickton was not only a known John to police and never held accountable for a long time while he committed these crimes, but he was also a screened John. Women had screened him and went out to parties on his farm, what was called Piggy's Palace, of course not knowing he was a serial killer. The notion that more time to screen men and an indoor venue is what will make prostitution safe has clearly failed women, because both of these things have not prevented women's deaths. We know that inside brothels is not safer, and we reject that we must accept the notion that men will be given social permission to their entitlement to demand that it is their right to buy women. Based on the lives of women in often the most dire and impoverished circumstances, those forced to prostitute in public space, we are continuing to reject their criminalization in any location. The Justice Committee amended Section 213 of the Act to a more narrow definition, naming areas near schools, playgrounds, and daycare centers. Even with this amendment, we are still calling for the full removal of this provision in order to eliminate the potential criminalization of any prostituted woman. I just want to address some points that have been presented by some opponents of the bill over the course of these hearings. There was a suggestion that the Vancouver Police Department has been executing the Nordic model in Vancouver for some time, and as a resident and crisis worker in Vancouver, I can assure you that that is not true. There has been little to no enforcement of laws against Johns or pimps, and we see this firsthand as advocates who have to press the police to even take a woman's statement, let alone do a full investigation. I can expand on our experiences more later if there are questions. In terms of the initiative of $20 million to be spent on helping women exit prostitution, we do think that federal money and political will is necessary, but we don't think that this amount is nearly sufficient enough in order to make real change. We think it's very important to address the conditions that get women into prostitution in the first place and provide a social safety net that doesn't force prostitution to be that social safety net. We need a guaranteed livable income, safe, adequate housing options, affordable childcare, and women-only detox and treatment centers. We do think that Bill C-36 has the potential to set a precedent in Canada that the buying and selling of women and girls by men will not be tolerated. And for this, we are hopeful the government will listen and follow the leads of women's groups and survivors. Vancouver Rape Relief and Women's Shelter stands firm in calling for legislation to criminalize pimps, johns, and profiteers for their violence against women, but we absolutely cannot endorse any criminalization of women in prostitution, and for this we call on the full removal of this provision in the bill. Thanks.
Ms. Stacey.
I'd like to begin by acknowledging that we're gathered here today on the traditional territory of the Algonquin and Anishinaabe peoples. My name is Lisa Stacey, and I'd like to thank the committee for inviting Michelle and myself to present here today on behalf of the Canadian Association of Sexual Assault Centres, which I'll shorten to CASAC. Founded in 1975, CASAC member centres continue to provide crisis support and intervention to women across the country. As women and as frontline workers, we witness every day and confront every day the rampant danger and routine violation of men's violence. The evidence accrued by listening to and working alongside the women who call our confidential phone lines and join our groups is the basis for all of our public positions on male violence against women, including prostitution. In 2001, our members insisted on and passed a resolution that prostitution is a form of male violence against women. In 2005, we further articulated our analysis that prostitution is a practice that capitalizes on and compounds the intolerable inequalities of sexism, racism, and poverty. We know that criminal law alone cannot and will not eradicate the desperate inequality that prostitution, like all forms of violence against women, exploits and entrenches. However, for decades, women and women's groups, including CASAC, have insisted that criminal law protect our right to equality by preventing and sanctioning the sexist violence that's perpetrated against us. Since 2001, we've advocated for a model of criminal law that completely decriminalizes women in prostitution. We're asking for an amendment to Bill C-36 that would remove Section 213 entirely. The amendment that simply lists specific locations is not consistent with an analysis of prostitution as violence against women, nor does it adequately respond to the nearly unanimous demand by witnesses for the removal of this provision. The definition of consent in Section 273.1 of the Criminal Code that follows the sexual assault offenses, a definition that is a hard-won legacy of the anti-rape movement, provides a useful framework to counter the argument that prostitution is a consensual sexual act. This section defines consent as voluntary agreement to engage in the sexual activity in question. And the brutal forces of poverty, violence, and racism that coerce so many women into prostitution effectively negate consent. We're encouraged that Parliament has acknowledged that criminal law can and should serve to condemn and curtail the continued prostitution of women and girls in Canada. Bill C-36 precisely targets the men who demand sexual access to the bodies of women and girls, who coerce them into prostitution, who prey on their economic and social vulnerability to recruit them into the sex industry, and who benefit economically from them remaining in prostitution. CASAC knows that the criminal justice system at all levels too often fails to respond to and investigate women's reports of men violence, and therefore too often fails to hold violent men accountable. However, we must not compound this by failing to criminalize the violent behavior of men who buy sex. Thank you.
Bonjour. En tant que membre
Good morning. As members of the Quebec Association of CALAX and as a member of CASAC, we obviously agree with the views held by my colleague. Bill C-36 is a promising start, but for it to reach its objective, the bill in itself is not sufficient. The government must demonstrate a real commitment by putting in place social measures to deal with those factors that force women into prostitution, such as poverty, sexism, and racism. Furthermore, the proposed $20 million for those groups who who do prevention work and who help those who want to exit the sex industry, well, they're not sufficient. Getting out of prostitution is a long and rocky road. The decriminalization of all prostitutes would remove one more obstacle, and I think that we could expunge their criminal record as it deals with prostitution, and that would really help ease their way out. Canada shares with the United States the longest border in the world. If we completely decriminalize prostitution, we would see an increase in demand, a staggering expansion of the legal sex industry, and an earnest explosion of the black market one. And that's not even to mention child prostitution as well as sexual tourism. Canada would become a haven for those who deal in human trafficking. However, Bill C-36 will dissuade all these people because it will make their life much harder. The idea here is to undertake a complete change in mentality so that no one feels free any longer to buy and sell the body of another human being. We demand that the Charter of Rights and Freedoms be respected, the charter that establishes safety and security for all, as well as equality between men and women. It is essential that the government commits to large awareness campaigns on the ills and the consequences of prostitution as a specific type of oppression against women. Ask yourselves the question, ladies and gentlemen, what kind of society do you want to live in? Do you want to see your children and your grandchildren grow up in? Do you want to see a society that normalizes sexual exploitation of women? Or do you want to see a society where the sexes are equal and where it would be unfathomable to purchase women's bodies? Thank you.
Thank you for this opportunity. Whoa. I'm a professor of criminology at the University of Ottawa, teaching in research methodology and violence against women. I've spent the last 20 years examining various aspects of the sex industry and have conducted hundreds of interviews with street-based, in-call, and out-call sex workers. As a researcher, I believe policy and law should be evidence-based. I thought, therefore, it was important to start with some comments about being discerning consumers of information, be it coming from research or from frontline service providers. Sex work is criminalized and stigmatized, and no one can ever have a totally representative sample. So any claim to speak for or about most or the vast majority of sex workers is by definition spurious. Moreover, samples drawn from organizations that provide services to women in distress are quite obviously speaking only to a specific subpopulation. These are important voices, but they cannot be generalized to sex workers as a whole, many of whom would never seek out this kind of service. To use an analogy that Professor John Lohman uses, it would be like extrapolating the experience of all women in intimate relationships from a sample of those in battered women shelters. What we know when we look at the complete body of credible evidence is that 80 to 95% of sex work is off-street, and that sex workers are an extremely diverse population with a wide range of experiences and labor practices. To restate a point made by other witnesses, regardless of why an individual is doing sex work, the provisions of Bill C-36 will not protect them. It will do the opposite. I refer you to my submission that details what the empirical evidence tells us Bill C-36 will mean for sex workers' safety and security. It is on the basis of those harms that I echo the calls of others requesting that this bill be, at a minimum, referred to the Supreme Court for a ruling on constitutional validity. I want to focus my remaining few minutes on the assertion that sex work is inherently violent. It's a foundational assumption of this legislation. Remove the inherently violent rationalization, and we are left with little more than legal moralism. We can certainly all agree that there are intolerable levels of violence in the sex industry. Indeed, that is the reason why 3 very courageous sex workers took this issue to the courts in the first place. What does it mean, however, to say that sex work is inherently violent? It means violence is inevitable and constant and intrinsic. It also means that nothing can be done about it. I want to challenge these 2 suppositions. The ruling by the Supreme Court of Canada that the violence of a John does not diminish the role of the state in making the prostitute more vulnerable to that violence speaks to the potential for laws to exacerbate risks. Moreover, while it may not be possible to eliminate the risk sex workers face, just like it is not possible to eliminate the risk nurses, personal care workers, and convenience store clerks face, we need only compare the rates of violence, including rates of fatal violence, between the street level, which accounts for 5 to 20% of the sex industry, and indoor sex work, where most sex work happens, to realize that context, labor context and legal context, matter. What about the idea that nothing can be done to minimize the violence? Replace the word prostitution with any other occupation, construction, logging, cab driver, and the statement becomes unthinkable. The response to danger at work should be, and usually is, to implement safety and security mechanisms. This is the approach New Zealand took in 2003, and sex workers are safer as a result. They are better positioned to negotiate services and safer sex practices with clients, have much improved relations with police. Indoor workers can, unlike their Canadian counterparts, avail themselves to occupational health and safety laws and other protections. It is worth noting that the argument that women should not be permitted to engage in sex work for fear of precipitating their own victimization draws on the same victim-blaming trope as the rape myth that women should avoid dressing like sluts in order not to be raped. It also entrenches the disconcerting stigmatic assumption about sex workers that I've heard bandied about in these hearings. Sex workers must be drug-addicted, mentally ill, or psychologically damaged to keep making these bad choices. Clearly incompetent subjects in need of rescue, not rights. In real terms, this perpetuates social and civic exclusion by ensuring sex workers who choose not to exit the industry will continue to face judgment from social service providers, health care workers, and law enforcement. Let's be clear. This law will not eliminate or even significantly diminish the sex industry, but it is attempting to protect sex workers by increasing the challenges in order to force them to make what others deem to be the right choice. Shockingly, it is doing so in a vacuum. It does not even attempt to address deep-seated inequalities of gender, race, and class that constrain women's personal and professional choices. Instead, Bill C-36 imposes a moral script, perpetuates victim blaming, and pledges $20 million to provide services to those who want to leave this dangerous and harmful activity. Support is contingent on workers recognizing their need for rehabilitation. As a criminologist, I am deeply concerned about the impact of the law. As a feminist, I am appalled. Since the 1980s, we have rallied for women's right to choose what they do with their bodies. Think abortion. Even when those choices are not what we personally would do, we defend and respect a woman's ability to make decisions for herself, recognizing that those choices are very often made in less than ideal circumstances. I am deeply saddened that in 2014, Canada is going the opposite direction, drawing on paternalistic rhetoric to justify criminalizing consensual sexual activity between adults. Thank you.
Thank you all for your opening statements. We'll now move to questions, beginning with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and welcome to our presenters here today for your excellent presentations that you have given to us for consideration. I have two questions. I have one for the professor, but I have another general question for the other presenters. One of the presenters, Ms. Smith-Tagg, referenced Section 213 and was very adamant that the section of this bill that criminalizes prostitutes be removed from the legislation. But I don't recall any reference by the other two presenters on this subject, and I'm wondering, Ms. Smith-Tagg said her words were practically all presenters were opposed to this section of the bill. I think your words were practically all?
I did ask for the removal, but it was actually Lisa who said almost unanimously.
Oh, so you did.
Yes.
So you did. So let us be perfectly clear. I'm a bit older than you are, so that you want this removed from this bill.
Yes.
That's clear.
Yes.
No doubt about it.
No.
Although you approve of the bill, but you want this section removed because it criminalizes the very thing that the minister said he didn't want to do and the department said he didn't want to do. This does it, doesn't it?
We do think that by criminalizing women in certain locations, it actually undermines the intent of the bill, which was to protect exploited persons. So we do think that it undermines that intent.
So the intent of the bill, you believe, is not to criminalize the prostitutes themselves. However, I might say that the minister, although he did make that statement before the House of Commons committee, when he came before the Senate committee, he was very adamant. He said, look, the act of prostitution is illegal and unlawful for the first time in Canadian history because of this bill. So the intent of the legislation, if you took the evidence of the officials before this committee, the intent of the legislation is to outlaw the act of prostitution. And the act of prostitution is defined, of course, as a two-way street. So now, Professor, you've suggested, as some others have suggested, that this matter should be referred to the Supreme Court of Canada to look as a reference, to look at its constitutionality. We had a couple of lawyers who appeared before this committee who said, no, they don't agree with that because you need a body of evidence. You'd have to have an evidentiary foundation in order to adjudicate a reference. But I suppose, Professor, your point is we already have the evidence in the evidence that was presented in Bedford, and they've adjudicated on all of these matters. And you believe that now a reference to the Supreme Court of Canada on this bill's constitutionality would be a good move. Is that correct?
Yes, because I think that it's quite readily demonstrable that this bill reproduces very many of the conditions that were at the heart of the Bedford decision. So under those situations, I do believe that they could look at the evidence already submitted, as well as evidence that has emerged since that, including the research done by Pivot and Kate Shannon in the BC Centre of Excellence on the experience in Vancouver when police did criminalize clients, went after sweeps after clients. So I do think that there is evidence that they can look at. I think it's really very distressing that we would have to wait 5 years, and the consequences of this bill, which I firmly believe will be horrific. Sex workers are going to pay a heavy price for this bill, and I think that's just too expensive a price to pay not to check.
Thank you.
Thank you. Senator Butters.
Thank you very much, all of you, for being here today and the work that you do every day on behalf of women and vulnerable women. I want to just start out, Ms. Smith-Tagg, I just thought so many points that you made in your presentation this morning were very, very good, and the fact that you're a frontline worker, I mean, the arguments in here are really excellent, so thank you for bringing them to our attention today. And I wanted to give you a bit of an opportunity. You said right in here there was a suggestion that the Vancouver Police Department has been executing the Nordic model in Vancouver for some time. We heard that yesterday, I think. And as a resident and crisis worker in Vancouver, I can assure you that this is not true. There has been little to no enforcement of laws against Johns or pimps, and we see this firsthand as advocates who have to press the police to even take a woman's statement, let alone do a full investigation. I can expand on that if there are questions. So I'm asking you that question. If you could please expand on that, because we heard contrary evidence yesterday.
So, I mean, for a long time, it was only women being criminalized for many years. And in the past few years, it's pretty much been hands off for everyone. There has been no criminalization. And as a woman who answers the crisis calls every day from prostituted women, you can't even get police to respond and actually take them seriously and get a charge or a conviction. And that's across the board for all violence against women. There's very low conviction rates, and I think it's especially true for prostitution.
Okay, thank you. I note that when Ms. Bruckert was speaking earlier, and she made the comment that that women should not be permitted to engage in sex work for fear of, the argument that women should not be permitted to engage in sex work for fear of perpetuating their own victimization draws on the same victim-blaming trope as the rape myth that women should avoid dressing like sluts in order not to be victimized. You had quite a substantial reaction to that, and would you like to respond to that comment that she made?
I didn't realize I did. I apologize for that.
That's okay. I mean, it's honest.
What was troubling about it is that this is not actually about demonizing women's choices. This is actually about calling out men's behavior and calling out men's role in buying and selling women and checking their privilege on the backs of women. It's not at all about women's choices or about blaming those women who are in prostitution. In fact, the opposite. I would blame the men.
Absolutely. We heard that from a lot of witnesses yesterday, and actually Professor Benedet, who, substantial legal authority on this type of subject matter in Canada. She testified yesterday, and she had a great quote when she testified before the House of Commons Justice Committee in July, when she said, and I think this is right along the same alley, I think there is something ironic about the argument that men must be allowed as a constitutional right unrestricted opportunity to buy women, to keep women safe from those very same men. Mm-hmm. And I think that's exactly what you're getting at with your comment there. Also, what I wanted to just draw to the attention again, because we heard more arguments of why that one particular small provision, which has been substantially limited, why people think that it should be removed entirely. And I just wanted to draw to the attention of those here that, of course, I was the Justice Minister's Chief of Staff in Saskatchewan for 4.5 years, so had a kind of unique vantage point into the criminal justice system in Saskatchewan. And of course, prosecutors and police have substantial discretion as far as charging authority, whether or not to lay those types of charges. And then, of course, there's also significant discretion by judges to be able to sentence appropriately and not to have sentences that don't reflect the appropriate disposition of an action. So I just wanted to draw that to people's attention. Sorry for the interruption.
Senator Joyal?
Yeah, we have the same rules here than in the Senate.
Yes.
And in the Senate chamber, it's totally forbidden to have electronic device that might disturb the questioning or, of course, the answer from a witness. So I would suggest, Mr. Chair, that you apply the same rules here.
Yes, and thank you for raising that, and remind all members that those rules do apply in this committee as well, and we would ask you to follow them in the future. Yes, sorry to interrupt the questions answers. Yes.
Okay.
Monsieur le Président, avec votre permission, Monsieur le Président,
Mr. Chair, with your permission, normally a lot of people have electronic devices on vibration. My device was not on vibration mode, but I can tell you that many have their devices with them. But I apologize for the disturbance, and I will seek not to do it again.
Can certainly attest to the fact that my always neighbor, Senator Dagenet, that's the first time that that's ever happened. So I apologize for that today. Yes, what I was just stating is that I was the Justice Minister's Chief of Staff in Saskatchewan for 4.5 years, and what I noticed from that unique vantage point is that there is significant discretion, both for prosecutors and police, in determining whether to lay charges in any sort of situation, and there's also significant discretion given to judges in sentencing. So I just wanted to draw that to the attention of those here. And yeah, sure.
What I worry about with that is that already police have discretion, and they use it often to not hold men accountable and to charge women instead. We see it with women who are battered women. They often charge the woman and not the battering husband. So I don't exactly trust their discretion right now. If there's a law there, I would be worried that they would enforce it.
I think that the difference, hopefully, will be with all of this is we're seeing a real paradigm shift with C-36 as a law to say that prostitution is not just mischief or nuisance. This is violence against women, it's exploitation of women, and it's not acceptable. And so I guess we're hopeful that that very strong message sent by the government to prosecutors, police, judges, everyone across the country, men, women, everybody, will permeate throughout the justice system. So, thank you.
I think that's a good point to make. The paradigm shift does make a difference, and hopefully to eliminate that it's mischief or nuisance at all would be our goal.
Absolutely, and having people, really competent people like yourselves, come and testify before our committee and talk about all these real-life stories very much helps to cement that in everyone's minds as well. So thank you again. Thanks.
Effort.
Thank you very much, Chair. Thank you to all of you for being here. I have found all your presentations very convincing and a lot to think about. I have, before I came here, worked with Vancouver Rape Relief and Sexual Assault Centers, so I very much appreciate the work you do, and you really work in very difficult situations. My question to you, Ms. Smith-Tegge, is that I also come from Vancouver and work with racialized and Aboriginal women. And I think one of the challenges is who is listened to. And the reason that Picton went on for so long is which women were being abused, And I find that when racialized women make the complaints, often there is no model. And it's hard to get their stories heard. That's been my experience even recently as last weekend. And so what you say, and I may be wrong because I'm not a frontline worker, but I find there's Nordic model for some women, and there is no model for some women, and that's the big challenge. One of the things that when we're looking at stuff, we feel that all women are equal. And you especially know that that's not the case when you do the work, that who is heard is the big challenge. And for that reason, as you said, that it's not just about criminal law, but we have to have police better trained, we have to have the prosecutors more, like we have to have prosecutor teams that just deal with this issue, we have to have judges better trained, and workers like you better resourced if you're going to deal with this. This bill is not going to change much without putting many resources in place. Would you agree with that?
I do agree that the criminal justice system would need a significant overhaul in order to actually respond to violence against women adequately at all levels of the criminal justice system. But I do think that this bill actually does send a clear message to society about the way men should behave and the way that men treat women in all facets of society. I don't think that just because some women choose prostitution means that all those women who don't should have to suffer it.
And the challenge I have with this bill is, I can't think of a polite way of saying it, and I'm going to try and find a way to say it, but it's halfway in, because it's a non-criminalization of women and yet criminalization of women in the public place. And, okay, in the House, they tried to amend that, but it's still, there are daycares everywhere, there are playgrounds everywhere, and the women that you work with will be around those areas. And so the reason I feel that if there is not going to be any charges against women, there cannot be, 213 cannot exist. That's my opinion. That's why I'm opposing this, because I feel it's halfway, and if the women that you work with and I work with will still be caught under this bill.
I agree, obviously I agree that Section 213 should be removed entirely. And I do think that, the majority here is conservatives, and you've heard almost unanimously that we're calling for the removal of this across the board from all witnesses, and I think there is some responsibility to act on that. However, I think the alternative to not having the bill at all with full decriminalization would be far more dangerous for women. So I still support it.
Did you want to add anything?
I think that I appreciate you articulating your concern that if there's any provision that remains in the bill that would allow the criminalization of women to continue, it would replicate the way that, excuse me, the systemic flaws and inequalities of how justice is delivered. So I do think that in Vancouver, Aboriginal women on the streets of the downtown east side would be much more likely to be charged. And so I do think that acknowledging the inequality inherent to prostitution and then providing one provision that lets you criminalize women who are the most unequal of all unequal women is a mistake. And I agree with Kira that there is a responsibility to hear that concern.
Thank you. I have a question, Professor. Professor, this bill is supposed to be answering what the Supreme Court said, at least it's my understanding, on Bedford. And perhaps it's not as much knowledge as you have on these issues, but I read Bedford again last night, and I read the bill again. And for me, it's not answering Bedford. Bedford talked about, the states, yes, the John are violent against, it's a mantra for me in the Bedford decision, yes, that the John are violent against women, but the state has a responsibility to not make women more vulnerable. And I think... Sorry?
Can you move to the question, please?
Sorry. So my question is this bill answering what Bedford asked?
Absolutely not. It's not going to make sex workers safer. It is going to reproduce exactly the same situations. And it's going to be the worst for the most marginalized street-based sex workers. Sex workers will go to where clients are. So if a client is trying to avoid criminalization, it doesn't matter if it's a sex worker or the client who's trying to avoid criminalization, it sets up exactly the same situation. We're back to dark alleys, isolated corners, no communication, quick hopping into the car without negotiating services. All the things that create the conditions that were around Bedford was about are going to be reproduced. It really doesn't matter which side of the equation you criminalize. This is what's going to happen. And I think the idea that street-based sex workers will simply abandon the street because of criminalizing clients isn't true. What they found in the Pivot report was specifically that sex workers ended up working longer, so they were actually at higher risk.
Thank you. Senator McIntyre.
Thank you, Chair. Thank you all for your presentations. I note that over the years, the subject of prostitution has been analyzed by a number of committees at the federal level and by a federal, provincial, territorial working group. To name a few, the Fraser Committee, 1983 to 1985, Standing Committee on Justice and the Solicitor General, 1990, Federal, Provincial, Territorial Working Group, 1992 to 1998, House of Commons Subcommittee, 2003 to 2006, and Standing Committee on the Status of Women, 2006 to 2007. And over the years, the committee has heard from researchers, police officers, policy experts, private citizens, and persons involved in prostitution all over the country. As a result, numerous studies have been published, resulting in several amendments having been made on juvenile prostitution. However, I note no substantial changes have been made to the existing regime governing adult prostitution, street prostitution, or outcalls. This may be the result of continuing differences of opinion concerning how best to approach this issue. What's interesting to note, however, is that the various committees and working groups that have considered the matter have been unable to come to any agreement on how to go about framing this activity. However, the working group were able to agree on one thing, that programs be developed to fund agencies to help those involved in prostitution to exit prostitution. And on top of that, the working groups also recommended that the governments of the day review their social programs, housing, crisis intervention, and counseling services to ensure that they effectively meet the needs of persons who engage in prostitution. So, as a group, I'd like to have your thoughts on this, and just tell me how difficult it is going about framing this activity, because in reading the material, that's what I found out. There is no quick answer.
I can.
And C-36 may not be perfect, and it may have flaws, but at least it's filling a void created by the Bedford decision.
What I think is going to be a major barrier is trying to solve the social safety net that we have right now that is almost completely gone. I mean, we have unlivable welfare rates, so women who are in prostitution and women who are not in prostitution are finding it impossible to live on welfare and have basic food and shelter for them or their children. And I think we need to solve the lack of housing or safe, affordable, adequate housing. All of these compounding factors are what drives women into prostitution in the first place. So although we do need to have exiting services available and access to education, we need to solve the problem of why women are getting there in the first place, and that's what we're really pushing for.
Anyone else?
If I may, I think one thing worth noting is that the Fraser Committee did actually come up with very clear recommendations, including decriminalization of at least some components of the sex industry, specifically body houses. And unfortunately, Parliament didn't listen to those recommendations and instead brought the communicating law in with really tragic results. I think we have seen a really good summary of the evidentiary record, and that is in Justice Himmel's decision. If you go back to the Ontario Superior Court and her decision, she looked at over 25,000 pages of evidence. She did a very careful analysis of who was a reputable, not a reputable, but a valid witness, an expert witness, met the criteria, court's criteria of what is an expert witness. So I think we have a really excellent summary of what the evidence says. And based on that evidence, these laws were overturned. So I'm back to the point that, based on the evidence, this law is going to create harms.
Joël.
Monsieur le Président, merci, Madame, pour votre...
Thank you, Mr. Chair. Thank you for your testimony. I will speak to Ms. Leveillé first of all. Ms. Leveillé, in your second paragraph of your brief, you are raising a question that is new here. You suggest that we expunge the criminal record of those people found guilty of prostitution. There's an easy reasoning to be made here. Because the law is unconstitutional, the law under which they were found guilty is unconstitutional, by definition they are not guilty. And secondly, the government supports that the objective of its policy is to consider all women who are prostitutes as victims. So we are essentially victimizing those women twice by maintaining their criminal record. We victimize them once there because they've already been condemned, and then by not expunging that criminal record, we are making it more difficult for them to rehabilitate themselves. So in this kind of context, would you suggest we contest the validity of the criminal records of the women who have been found guilty of prostitution? In fact, we are thinking about all of these issues now. We are telling ourselves that these questions have been raised today at the light of Bill C-36, that these women who have criminal records for having been sexually exploited should not have a criminal record. The reason why we're saying that is, first off, because of the amendment that we want to 213, that would make it impossible to criminalize women. But also, with pre-existing criminal records, what those do is create tremendous difficulties for women when it comes to social rehabilitation. Whether it has to do with lodging, whether it has to do with studies, jobs, yes, of course, jobs. It creates huge obstacles for them. And women who want to exit prostitution are already faced with so many difficulties, so many hoops to jump through in order to simply reclaim control of their lives. So expunging criminal records would be the least we could do. And then, of course, we could add all the other things to that, more social measures to help them out, help them exit the sex industry.
Which is, in my opinion, very, very fundamental. You have probably read the presentation of the Minister of Justice and of the officers of Justice Department who contend that the objective of this legislation is the one enshrined in the preamble, which states that and is based on the assumption that all women who are in the prostitution activities are victims. And it is on that basis that they contend that the sections of Bill C-36 that are I should say, questionable constitutionally will survive, because they will have to be balanced on the basis of the objective that women are victims of women who are prostitutes are per se victim, inherently victim. And it is on that basis that, as I said, the section related to communication and so on would survive a constitutional test. What you say to us this morning is that this premise is wrong. It's false. That's what you say in your presentation on the last to one paragraph, that sex work is inherently violent. It is a foundational assumption of this legislation. Remove the inherently violent rationalization, and we are left with little more than legal moralism. So in other words, if you would be in court, you would challenge the very objective of the principle on which this legislation is based. And how would you make that proof to the court to be successful in your challenge?
Okay, do appreciate that I'm not a lawyer, so I will do my best. I think the evidence that I have put forward, the information I have put forward, that in fact, while there is certainly victimization in the sex industry, we need to look at the idea of inherently violent means that nothing can be done, and things can be done. It can be lessened. So I think I take issue with this premise of victims. I also suggest that if that is the intent and what we are going to see is that the outcome is going to be greater harm, then on that basis, I suspect it will not be constitutional. You cannot have a law that, ostensibly protects and helps victims, but actually puts those people who refuse to, who perhaps don't exit or are not able to exit, puts them in harm's way. That to me sounds like a very, very solid constitutional challenge.
In a second round, Mr. Chair.
Thank you, Mr. Chair. I'll ask the witnesses to put on their headphones. My question is for Ms. Smith-Tague. You mentioned, Ms. Smith, that historically police and prostitution don't go very well together. I'd like to know what you think police could do to help prostitutes, or what could be done to simply improve the relationship between cops and prostitutes, because, sometimes cops could very well protect prostitutes.
Removing any criminalization or the threat of them having a criminal record or a charge against them would absolutely help the relationship. I do think that because of the historical relationship between a lot of women who have faced violence and police, it isn't going to happen overnight, absolutely. I think that police need to know that women can have access to advocates and support groups and women's groups that they can go to and facilitate that relationship with the police. Because women are more likely to want to report once they trust someone. And often we actually work with the women in order to help facilitate them reporting to the police and getting a better response and holding the police to actually give a response that she's entitled to. So I think the removal of any the threat of criminalization would absolutely help that. And then police need to follow the legislation that they have and follow the policies that are in place and respond to violence against women more adequately.
Avec votre permission, Monsieur le Président.
With your permission, Mr. Chair. Ms. Smith, for a few years already, a lot of women have become police officers, and we also know that there are police officers who devote themselves to particular cases. Do you think that has helped improve the relationship between female cops and prostitutes? Because you know that the female cops are sometimes mandated with certain files like this one.
I have personally seen some police officers who do a fairly good response, and individual police officers who care and work hard. But until there's actual systematic change within the police force, which is followed by all police officers, it doesn't really go anywhere. If it's only one good police officer, then it's not going to go. Sometimes once it gets to Crown, then charges are dropped. So we're at the next level of the criminal justice system that fails women. Most charges for all violence against women, this is not just prostitution, are dropped at the police level. And we see that based on a lack of evidence. And I think that women are discouraged by that and not wanting to report.
Merci beaucoup, Madame. Merci, Monsieur le Président.
Thank you. Senator Boisvenu.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. Thank you, all of you, for your very interesting presentations. Michelle, hello. It's always a pleasure to see you again. And I congratulate you for the work that the CALACs do with people who are sexually assaulted. You do very good work in Quebec. In your submission, you lay out a position. You say that Canada shares with the United States the longest border in the world, and if we completely decriminalize prostitution, we would see an increased demand and a staggering expansion of the legal sex industry, as well as an explosion in the black market one. Professor, your position is a bit to the contrary of that. You are suggesting a liberalization of prostitution. And I'm trying to see how we can sort of marry both positions, the position of CALAC and yours, all the while knowing that if Canada adopts laws that are weaker than the ones we find to the south of us, whether it be about drugs or whatever else, or pedophilia. I can think there we were stragglers in laws against pedophilia, and we saw at a certain point people who were coming here to in order to escape pedophilia laws in the United States. So, Professor, I'm trying to understand what you base your argument for legalization of prostitution on, when we know that our neighbors to the south do. And like Ms. Leveille says, if we do legalize prostitution, we're going to see an increased demand from the United States. Is that not a concern if we legalize prostitution?
Go ahead.
I base my call for decriminalization and not legalization on the safety and security and health and well-being of sex workers. So for me, that has to be first and foremost. We cannot have laws or a legal regime that creates harm for one population of predominantly women, although not only. That's why you say, so how do I resolve it? That's how I resolve it. I think we need to, certainly there are already laws that need to be enforced around things like trafficking. That's fine. We have a very robust criminal code. I also think that we need to really recognize the violence that sex workers experience. So just to respond to some of the comments, I think it's important to, I would certainly agree that police do not respond adequately to violence against sex workers. This is often where we get the, just a whore mentality that is what Jeffrey and McDonald call it. And so I think we need to move towards recognition of human rights as well as labor rights for sex workers.
Mais lorsque la Nouvelle-Zélande...
Yes, but when New Zealand opened up its legalization of prostitution, it did it because they said we are an island and we're not going to have too many external influences. Clients won't come here by boat. The fact that we have such a close proximity with our neighbors to the south, and that we have a weaker prostitution legal regime, as a professor and as a researcher, don't you see danger there? And second part of my question is, should we not try to keep some sort of competitiveness in legislation with the United States so that Canadian women, Canadian prostitutes, don't find themselves in a weaker position?
So I'm not completely clear on this idea of equalizing it. Again, I'm not sure how Canadian sex workers will be disadvantaged if the position is different than that which is in the United States. Again, I think Canada is a sovereign state and we need our own laws. And I'm not convinced, by the way, that New Zealand had that conversation, that we're an island state. My understanding is that New Zealand brought in the laws because they put the safety and security of sex workers first, and the laws I'm talking about are actually a decriminalization. I should be very specific. It's not the same as legalization, so I'm not quite understanding.
Michelle? Well, I think that anywhere we have more lax legislation is where we've seen an increased demand, an expansion of the sex. I'm not going to repeat what I said in my submission. I think that the first thing we need to do is change mentalities. And we know that laws do change mentalities, especially if they are supported by an awareness campaign or awareness campaigns. Now, it's clear that if we have, whether we decriminalize or legalize, we are almost assured of an increased demand from our neighbors. And, we had other types of legislation, and we saw the effects of those during events in Montreal and whatever. And what you also need to remember is that everywhere where prostitution was legalized, there has been a black market regardless. So a large part of the sex industry takes place underground. And it would surely happen here as well. We're no different from anywhere else, I don't think. Our difference with the New Zealanders is our large border with the United States. And I'd also like to say, the more prostitution you have, the more violence you'll see.
Thank you, Chair. Professor, I want to continue along the line of what Senator Boisvenu started. I would suggest that there is a very fine line between decriminalization and legalization. There may be two different things, but they are awfully close together. Now, in your brief or in your presentation, you used a comparison of construction workers and loggers and hairdressers with prostitutes, and we aren't criminalizing them for fear of abuse. I'm not sure where you were going with that, but I have yet to hear of a construction worker or a logger or even a hairdresser being brutally beaten because of their line of work. They may have been beaten for other reasons, but certainly not because of their line of work. They haven't been raped because of their line of work. And so I'm not sure why that comparison, but yesterday Megan Walker used, and I'm going to read a quote here, or read what she said. Legalized prostitution does exist in Germany, and as a result of prostitution-related activities, there have been 22 murders of prostituted women in Germany, all related to interactions between prostituted women and the John. 22. That's in legalized Germany. In Sweden, where they have the Nordic model, which is what we're advocating for here, there have been 0 murders. Not one woman has been murdered in prostitution-related activities. I would like you to respond, number one, how you rationalize using a construction worker and a prostitute and comparing them and these stats. And these are correct stats.
Okay, so I have to, I will do my very best. And so the point I was making is that our normal response when there is risk at work is to increase safety and security. And so it's not true that sex workers are the only population of women workers who are at risk of violence. 29% of direct service nurses providing direct service, according to StatsCan, were victims last year of patients or their families. So certainly those kinds of statistics are really scary, and what they mean is we need to increase safety, security, we need to put in protocols. So that is what I'm calling for. I'm calling for a recognition that if we acknowledge that sex work is work, we can start to move towards increasing their safety and security like we would for any other worker. And I do take, I appreciate that for you, legalization and decriminalization are very, very close. To me, they're quite different. The difference is that in decriminalization, unlike a legalized regime, which essentially says some sex workers can work legally, but most, if they don't fit this particular profile, they can't work. And so you end up with exactly what my colleague was talking about, in that you end up with a huge black market. That hasn't happened in New Zealand because they took a rights-based approach. They brought in human rights. Well, they didn't bring in human rights. They made the same laws apply to sex workers as they do to anyone else. Occupational health and safety, labor rights, labor code. It applies, and that works, and that makes sex workers safer.
And of course, we're trying to make things safer for sex workers here as well by passing C-36. To any of the other ladies or all of them, some witnesses who have appeared here and are appearing here this week are advocating for the legalization of prostitution because they argue that it is a legitimate profession and should be viewed as such. How would you respond to somebody suggesting this is a legitimate profession, as possibly has been suggested here already this morning?
So one thing that I want to make very clear is that our position, while being different, isn't accusing the women who tell their own stories about their life that are different from ours or that come to a different conclusion of lying or not understanding or being too stupid to understand the way that their life is. However, I think that the argument that it's a profession negates the fact that it is a profession to which very few women aspire. It's a circumstance that replicates the inequality. Somebody, I think, said yesterday that if it's a line of work that's freely chosen, does this mean that Asian women overwhelmingly choose to be in massage parlors and Aboriginal women overwhelmingly choose to be in the most dangerous types of street-level prostitution? I think that the exchange of money I see as a way of capitalizing on and coercing women because of their poverty and their dire need for money.
I'd like to ask the three witnesses who are doing frontline work with prostitutes to respond to Professor Bruckert's assertion that prostitution is not inherently violent. We actually heard that from Valerie Scott yesterday as well. They also both seem to believe that Bill C-23 will make it more violent, but it's not inherently violent. Can you tell me what you think of that assertion?
Sure. Well, I think it has been recognized by almost all witnesses that there is obviously a need for safety and security of women, so that it kind of contradicts that it is inherently violent, because we have to be talking about how to keep women safe in this profession specifically. And just because not every single John may be violent with every single woman who is prostituted does not mean that it's an equal transaction. It doesn't mean that men don't have the power to do that at any moment, and that women aren't in a position of vulnerability to that violence. And we do see that a large number of women are attacked by men, and men use that position that they have to attack women and gain access to them. The very act of even buying a woman, I mean, they're paying a woman so that they can do what they want. I mean, they do have more power in that situation.
We also haven't discussed very much in these past few days the health consequences, just the health risks, the disease, infection, cancer risks, all kinds of risks, in addition to just the physical violence.
Absolutely, yeah.
And Professor Bruckert, you asserted that this bill perpetuates victim blaming, and I'm curious to know what part of the bill you think does that.
The entire framing of sex work as inherently violent and the push towards ensuring that women exit, in fact, that the only goal is to ensure women exit or sex workers exit, suggests that those who do not exit will be blamed for the violence that befalls them. This is a classic trope. We hear it from the police, high-risk lifestyles. That's how I feel it perpetuates victim blaming. And, you know...
It's so the idea that women who are in prostitution can and should have to take measures to ensure that men don't perpetrate violence against them is more accurately named as victim blaming. That's what's similar to me to rape myths, is saying instead of saying it's not okay that he did that to you, saying to women, why were you in that place? Why were you doing that thing? Why didn't you know better? Why didn't you see the red flags? I think screening is basically telling women that they're responsible for seeing red flags. Same way with domestic violence and rape.
So just to be clear, that's not, to be clear, that's not part of this bill, though.
No, I know.
Yeah.
I think that I'm just disagreeing with Professor Bruckert.
I'd also like to say here that when we talk about having more time to screen a John and negotiate the terms, to me, it's clear that that's not going to make things more safe for sex workers. I've been working with sexually assaulted women for over 20 years, women who have been assaulted by people they know, by their partners, and in the prostitution world it's the same. It might be a client that a sex worker has seen a number of times and who one day decides to attack you. And I don't think with an extra 5, 10, maybe 15 minutes of screening and negotiating time that we're going to make women safer.
McInnes.
Thank you, Mr. Chairman, and thank you for coming. A couple of quick questions. The trying to get a fix on how we can handle and transition prostitutes from the industry, from the trade. And it seems to me there's a number of programs out there now to do that. The great challenge is to get them to it. And I'd like your comments on how we might do that, because it seems to me it's not only concurrent, it probably involves, the federal, the province, and of course the municipality. So there's programs there, but getting them to it, I think. So I'd like your comments on that. The other one, and I've not heard this mentioned, and I want to put it on, I guess, on the record, because, the amendment that the House of Commons Committee put in place with respect to communicating for sexual services and near daycares and playground and schools. No one yet, none of our presenters, has mentioned the right of the child that I've heard. I know of factual situations where, in the province of Nova Scotia, where parents had a terrible time going to the daycare, going to the school to pick up their child, and not only were there drug paraphernalia, condoms, in fact, individuals having sex in the back seat of a car. So it strikes me that, and I kind of get a theme here, that we should be eliminating that law that will come in. And I think there's a danger here. And, the right of the child is important. The right of the family. When women pick their child up, they have to walk with their head down quickly to get to their car. I'd like your comment on those.
Well, first of all, I'd like to say that if we criminalize the purchase of sex, the criminalization of purchasing would be done everywhere. But if we criminalize prostitution entirely, we could probably see it increase a bit everywhere. I also think it's important to remember that we do not criminalize women who are victims of conjugal violence, even if they have children who are witnesses to that violence. Women, the exploited women of prostitution should never, ever be criminalized, ever. We criminalize the people who want sexual services, Johns and what have you, who solicit the women, not only women in prostitution, but all women. You might be waiting for the bus, and a guy might come up to you and ask you how much you cost. And that happens frequently, and a bit everywhere. So we we need to figure out how we can't guess if this solicitation was done by the John or the sex worker. But that being said, I agree that it's very unpleasant to find people in unsavory situations when you're taking your child to the daycare, of course. Now, as it pertains to encouraging women or getting women an easier time coming out of prostitution, women in that situation often have problems with self-esteem. They've been betrayed more than once in their life. And I think the best idea is to have shelters where there is no judgment, where they get help. And whether or not they go back to prostitution is entirely up to them and not to us, the interveners. All we can do is create, a relationship of confidence and help them rebuild their self-esteem, and then be by their side no matter what they decide to do. When I go see people, women show up with no ID cards sometimes, no other education, no jobs. So we stand by them throughout all those processes, which take years. Does that answer your question?
We are now at the second round, and we'll begin with this again with Senator Baker.
Just a clarification on what was changed in the House of Commons relating to 213. There are two sections to 213. One is offering, and the other one is communicating. So the new law now says this, 213.1, everyone is guilty of an offense punishable on summary conviction who in a public place or in any place open to public view for the purpose of offering, providing, or obtaining sexual services for consideration. That's the new law. The second portion of the new law is what was changed, the communicating section, on the next page. That's the wording. We just verified it a moment ago. So what remains in place in 213 in this new law is the offering or providing. Everyone is guilty of an offense punishable in exchange for consideration. So you're criminalized if you offer in a public place or a place open to public view. So that remains. It's only the communicating that's been changed to close to a school or playground. So with that clarification, I suppose even more so now, you would suggest that the entire Section 213 be removed. Is that?
Yes, absolutely.
Because it's not, as some of the senators have pointed out to you, the section has been changed. The important section is what will drive the prostitutes into the dark alleys in offering. So you recommend not the removal of the section that deals with schools and playgrounds. You're asking for the removal of the entire section.
Yes.
Thank you.
Senator Butters.
I'm just looking for a little clarification on that, which might take me a bit to find, so it may not happen this particular round. But I think that the importance on that would be the fact that we are immunizing, in many cases, the prostitute for many different types of offenses, which include the provision of their own sexual services, advertising their own sexual services, aiding, abetting, conspiring, attempting to commit an offense, being an accessory after the fact, or counseling a person to be a party, if that offense relates to the offering or provision of their own sexual services. And that last part is in 286.5 sub 2. So I think that might cover it off, but just because this was just brought up, I might need a little clarification later. The point that I wanted to raise before that was brought up, I'm not sure if Ms. Smith-Tagg, I'm not sure if you were here when Minister McKay testified or if you had any opportunity.
I wasn't here for it, but I did hear some of it, yes.
Okay, all right. When he was here the first day of this particular pre-study, I just make reference to this because in your opening statement you talked about the $20 million initiative, and in your view you thought that it wasn't enough. And I just wanted to reiterate that what Minister McKay stated was that the $20 million is in addition to other very substantial programs that are offered through the Federal Department of Justice, Aboriginal Justice Strategy, Victims Fund, all of those kinds of things. As well, something that he didn't get into, but Aboriginal Affairs Department has funding that goes directly to First Nations and also the Status of Women Department as well. So the $20 million is just simply one piece of a much larger pie. And then we also need to keep in mind that our provinces are responsible for social services, et cetera, and they have funding envelopes to deal directly with these kinds of issues. And from Saskatchewan, I know provincially that provincially we spend significant resources in all of those different areas, including the Provincial Department of Justice through the Victims Fund, Aboriginal Justice Strategy, and all of those other departments. So I guess I just wanted to provide some comfort that that is not the only piece of the pie.
I do realize that, it's true. And although 20 million is only one part, it still has to be spread out over 5 years across the entire country, which makes it even less for the provinces. I do agree that, of course, a lot of it is provincially controlled, the funding, and there is no initiative for the federal government pushing the provinces to spend more money on rights of women. Right now, in British Columbia, there's huge cuts to healthcare providers, to frontline services, to detoxes, to all these services that are just being erased, and that is what adds up. So we see those are the compounding factors in BC. So unless there's a push for the provincial government to actually take initiative on it, then we may not see the results. We'll only see some of the money that trickles down from the federal government.
Right, and that might be an issue that can be discussed at federal, provincial, territorial justice ministers' meetings. They meet usually at least once a year, and I'm sure prostitution will be a big item on their agenda, and that's something that they could perhaps discuss. Thank you.
Okay, we have about 6 minutes left. We have 3 senators who would like to ask questions and receive responses in that time. So if they have quick, to the point questions and similar responses by our witnesses, we could accomplish it. And we'll begin with Senator Jaffer.
Thank you very much. Now, this morning, listening to you all, what you say is so persuasive, but I'm so troubled that this bill says one thing, but yet it still criminalizes women. Women still cannot advertise. And the women who are the most marginalized, who are on the streets, they cannot go to a commercial place. So they often don't have a place to go to. So where do they go? So in one hand, it gives some rights, but it doesn't really help people. And I'd like your opinion on that. And, I don't have much time, and I'd like to hear your opinions on it.
I would say that in light of the alternative, which is the complete decriminalization of prostitution, which I think ensures more prostitution, more women seeing more men, the violence comes from those men who either have a vested economic interest in getting them into and keeping them in prostitution, or who purchase them in prostitution. And I don't think that women are protected by an increase in the amount of women that men have access to.
That's good. Senator Joyal.
Professor Brockett, I would like to come back on the assumption on which this bill is based, which is that all women in prostitution, or all persons in prostitution, I should say, are victims of some sort, either victims of themselves or victims of the social conditions or pressures of family situation and so on. How would you prove in the court that persons who are involved in prostitution are not per se victims?
Okay, and not ever to say that sex workers are not victimized, because I'm quite clear that there is a great deal of victimization. I think the testimony of sex workers speaks volumes, and you have heard some sex workers, current and former, speak here in previous days, and you're hearing more this afternoon. I think you have to listen to what people say about their own lives. Listen to it, hear it, and respect it. And I think that speaks volumes.
But you mentioned also that the street-level prostitution represent only 5 to 20%
That's right.
of what might constitute the number of prostitutes, or the average number of prostitutes. Do you have any figures of those who are not on the streets and, in your opinion, work safely?
What do you mean by figures? I'm not quite sure.
Numbers, percentage of those women or persons in prostitutions who would consider that they are there freely on their will and are not coerced or are not pushed into prostitution, but they have chosen by themselves to be in prostitution.
Right. So there's a great deal of research. The problem is, and I'm just going to be really ethical and honest, that no research can have a representative sample. So no research can ever tell you this percentage of anything is like this. In the sex industry, it's criminalized, it's stigmatized, we just don't know. There's a great deal of research that talks about sex workers having a wide spectrum of relationships to the sex industry. And so very, very many sit on the spectrum of choice, mediated choice, constrained choice. There's a whole, two situations where there's very, very little, very few options. And I think when we say choices, we're really meaning about meaningful choices. So I have no numbers. We cannot have numbers while this industry is criminalized, because we will never know.
Thank you. Last question, Senator Dejenet.
Monsieur le Président.
Thank you, Mr. Chair. My question is going to be for Ms. Leveille. Obviously, reducing demand by criminalizing the Johns is to reduce the opportunities for organized crime to traffic women, and that's essentially, in part, what C-36 is seeking to do. Given that prostitution is not an activity that's undertaken with a permit, prostitutes, should they not be concerned that the simple legalization of prostitution would bring a wave of American prostitutes, which would reduce the opportunities to do their own job, except in a situation where there are children nearby? What would you have to say about that? Well, in fact, in those places where we've legalized prostitution, what you see happening is that demand increases so much that competition increases, if you will. Not, you're talking about American prostitutes come stealing our jobs, if you will, in this case, the jobs of Canadian prostitutes. But you would also see an increase in human trafficking. I don't think there would be enough demand to supply everyone. I don't think that would be a concern. There is certainly women prostitutes coming from everywhere and who do it by choice, or for the most part, who find themselves in Canada against their choice.
Committee's deliberations. We are going to suspend briefly and allow our next panel to take the seats. Come to order, please. For our next group of witnesses, welcome representing Maggie's, which is a Toronto Sex Workers Action Project, Nicole Matt, who's the Vice Chair of the Board of Directors, and Jean McDonald, the Executive Director of the organization, and from an organization called Stella, Anna Ode Cowett, who is a spokesperson for that organization. So, Ms. Matt, did you wish to lead off with an opening statement?
Yeah, thank you. I'm a board member at Maggie's Toronto Sex Worker Action Project. I have a background in feminist anti-violence advocacy, women's sexual assault support, youth sexual health education, and sex work theory from an academic standpoint. At Maggie's, we work directly with current sex workers, and the service users we work with tell us that they are, quite frankly, terrified about the impacts that C-36 are going to have on their lives. We're seeing that street-based workers still fear the same police repression that they've suffered for many years. Those working alongside fellow sex workers in safe in-call locations are canceling their leases and opting to work alone. Some who felt most comfortable working for an agency wonder what else they're going to do to make money in a tough economy, and they really lament a missed opportunity that could have given them the same basic employment protections that other Canadians enjoy in the workplace. So already we're seeing this legislation isolate workers who have been working safely, and we anticipate these dangers will further spread throughout the community if this legislation becomes law. Inequalities in sex work are the same inequalities that plague all sectors of Canadian society. Histories of colonialism, racism, sexism, and transphobia mean that Indigenous women, racialized women, and trans-identified folks are overrepresented in sex work. But it's important to keep in mind that these marginalized groups are overrepresented in underpaid, marginalized labor across the country in all sectors. Bill C-36 does absolutely nothing to address the systemic roots of oppression and inequality in our country, but rather it proposes to further marginalize and stigmatize the most vulnerable of Canadians. Sex workers will continue to work, no matter the level of criminalization or risk put in front of them. Our service users still need to pay their rent and feed their kids. And this has been proven time and time again by the World Health Organization and the UN AIDS organization and other anti-violence organizations that are demanding full decriminalization of prostitution worldwide. Indeed, some sex workers want other jobs, but just like other low-income Canadians living paycheck to paycheck, they cannot transition overnight. Where vulnerable street-based workers are forced out of the trade by police crackdowns and repressive legal environments, we only see a displacement of these workers. Their criminalization did not erase them, but it might have pushed them back into a relationship with an abusive partner, for example, so it makes them more vulnerable. Some representatives here today argue that this legislation represents a, quote, paradigm shift in the way our country addresses inequality, and I wonder, is it compassionate to sentence your country's most vulnerable people to a more precarious life? Sex workers are not just symbolic representations. We're living, breathing Canadians who are going to suffer under Bill C-36. Thank you.
Ms. McDonald.
Hello, everyone. My name is Jean McDonald, and I'm the Executive Director of Maggie's, the Toronto Sex Workers Action Project. I'm not going to lie. I came into this week of Senate hearings with a sense of futility. I have the sense that no matter what I say, no matter what current sex workers say, that our views, evidence, and arguments will not be taken into consideration in regards to Bill C-36. However, I am here, and I want to dispel some myths. I want to explain some realities. I want to tell you how Bill C-36 will impact current sex workers on the ground, working, paying bills, indoor, outdoor, with choices more constrained and less constrained. Bill C-36 will criminalize consensual adult sex work. We have heard many awful, tragic stories this week. Bill C-36 does not deal with coercive sexual relationships, sexual assault, rape, abuse, murder, physical assault, forced confinement, and other clearly terrible acts. We have criminal laws that on the books, and when the 3 laws were struck down by the Supreme Court, those laws remained on the books. When I argue that the decriminalization of sex work is the best way to protect sex workers, I'm saying that we need to uphold those same laws that would protect everyone, that are on the books, that forbid sexual assault, rape, forced confinement, etc. I believe that adults, men and women, have the ability to consent to sexual acts. Why is our ability to consent suddenly revoked when there is money on the bedside table? There's been a lot of talk this week about violence and the violence that many sex workers face. Some have even asserted that sex work or prostitution is inherently violent. I want to address the violence that sex workers face, and this is why I support decriminalization. This is to ensure that sex workers can have access to the same labor, legal, and human rights as any other person in Canada. This is essential to ensuring our safety and security. Some witnesses have suggested that screening clients cannot completely protect sex workers, and therefore they're in agreement with communication laws and criminalizing clients who therefore won't be likely to provide screening information. And it's true, yes, no one can be perfectly screened. Similarly, seatbelts will not completely protect car passengers from injury or even death. But I would never deny someone the ability to wear a seatbelt. Some analogies have also been made to domestic violence. You could date a man, he's wonderful, you're in love, you marry him, and then it's not until the honeymoon that he becomes abusive and controlling. It's true, that could happen. In fact, women in Canada are very likely to face abuse and violence within spousal relationships. According to a StatsCan study in 2011, there was, on average, one woman killed by her spouse every 6 days in Canada. Shall we ban marriage next? Is marriage inherently violent? Or, similar to the legal supports and laws that we have created and should continue to create to protect survivors of domestic violence, we need to make those same kinds of legal rights and social supports available and more accessible to sex workers. If we truly want to address some of the reasons why people get into sex work, some of the more constraining reasons, we need to increase minimum wage. We need to increase welfare rates, disability supports. We need universal child care and affordable housing. We need free secondary education and job training. And in order for single moms, many of those sex workers we work with are single moms. And if they're going to be able to exit prostitution and change their life, they need free child care. And childcare in this country, and I know because I'm a mom, it costs me about $1,200 a month simply to have my child in daycare, okay? And when you're someone who makes about $3,000 a month on my salary, that's really small, like that's a huge chunk of money, right? I lost my train of thought there. But what we need to do is increase the options that people have. We need to increase those options. We need to increase social supports rather than, diminish or criminalize the few options that people might have. Thank you. Oh, and I just wanted to say I have some thoughts on how B36, piece by piece could be challenged according to the different provisions of it. So feel free to ask me more specific questions.
Okay. Ms. Kawat, do you have an opening statement?
Merci.
Thank you, Mr. Chair. Hello, my name is Anaoud Kawet. I work for Stilla. That is a feminist organization that's sex worker driven out of Montreal. We focus on human rights. We were founded in 1995. And Stella's mission is to work with street workers, to provide them with services and to defend their rights. Every day we meet with sex workers in the various sectors where they work, or out on the street, or in massage parlors, in call, out call, escort agencies, strip clubs, and dungeons, and sometimes even in their own homes. At Stella, we also organize a bi-weekly health clinic in partnership with the CLSCs, or local community health clinics. Along with our members, we create violence prevention tools, like, for example, a violent clients list, which is drawn up with the help of sex workers, and then we disseminate that list to people in our communities. Hundreds of sex workers and partner organizations have access to that information and distribute it within the sex worker community. We also accompany sex workers, whether they're trying to get medical, social, or legal service appointments, and every day we answer over 5,000 calls on our helpline, and we offer these support services to break their isolation of sex workers, and also to set up the kind of confidence-based relationship within the community, because we know sex work is so stigmatized and it's so hard to talk about it openly with just anyone. At Stella, we are women, we are trans women, we are also students, single mothers. Some of us are drug users, yes. Some of us are teachers, nurses. In fact, we could very well be your mothers, your daughters, we could be your aunts, we could be your sisters. We are whole members of society, and we are also your neighbors. We are very worried at Stella. Our sex worker members often ask us questions about C-36. We criticize this bill because we find that we are picking up the same provisions in C-36 that were just invalidated by the Supreme Court by simply changing the wording a little bit. And we continue, nevertheless, to criminalize sex work, and that is of great concern to us. In its decision, the Supreme Court explained how and why the provisions of the Canadian Criminal Code lead to the violence that we see in sex work today. So the perspective of C-36 ties prostitution to violence, almost equates it. And those of us who have not had that experience of violence in sex work, well, we find our experiences essentially cast aside, and we're not thought of. So for those of us who will continue to work in sex work, or who are currently working in sex work, we are going to be the ones to feel the full brunt of this bill. As my colleagues were saying, C-36 equates prostitution with violence and creates ever more conflict in the already delicate relationship we have with police officers. Those who work at Stella know very well the working conditions of sex work. They know that all these sex work experiences are located on a continuum. Some of us might be victims of violence, among other reasons, for what we call slutophobia. But when it happens to us, it is no less a crime than when violence occurs to any other woman in Canada. You are mistaken if you think that by adopting C-36, you will make it easier for sex workers to report cases of violence to the authorities. When our work and our lives are criminalized, it is very difficult to us to report a violent crime against us without risking losing our source of income or the professional relationships that offer us support. Police services are essentially excluded from the list of possible resources for those sex workers who are victims of violence. A discussion needs to take place about where and how sex work takes place. We need municipalities to undertake a respectful and significant dialogue with sex workers to find solutions that are community-based. And it is a mistake to think that Bill C-36 provisions are going to reduce violence against Indigenous women. In fact, using the criminal code once again to deal with prostitution, and more specifically to save us, simply reinforces the legacies of colonialism and places Indigenous women in even more precarious working and living conditions. To tie prostitution so inherently to human trafficking is also dangerous for people who work in sex work. Sex work is not in and of itself coercion. We need to listen to sex workers when they tell you what is going on in their lives and what are their experiences with violence and prostitution. There are even international organizations such as the Global Alliance Against Trafficking in Women that energetically object to this equation, and they also state that this type of approach does nothing to reduce the danger of sex workers. And let's not forget that our colleagues in France have just rejected a bill criminalizing the purchase of sexual services in France. Criminalization of sex work increases inequalities because it makes sex workers go through even more violence and discrimination and poverty. And that reality was the one just recognized by the Supreme Court in the Bedford decision. Let us stop thinking that the criminal code is the only way to deal with the issue of prostitution. In the Bedford decision, Canada's Supreme Court clearly stated that using the criminal code to protect sex workers had the opposite effect. And I'll end on this. It put sex workers at risk. So to improve our health and our security, we should use other regulation tools instead of even more marginalization. Thank you.
All of you for your opening statements, and we'll begin the questions with the Deputy Chair, Senator Baker.
Thank you, Mr. Chairman, and thank you to the witnesses. Is there anything in the bill that you like?
I'll reply. Well, from Maggie's perspective, we are rejecting this bill wholesale. We wanted to see a full decriminalization of sex work, specifically the 3 sections that were struck down by the Bedford case. So anything that is going to reproduce the harms that Bedford recognized that were posed by those laws, we will not accept those. So what we're seeing with Bill C-36 is a reproduction of the same criminalization around communication laws. It may have reversed it, as some are calling asymmetrical, and we're seeing that will, working directly with sex workers, sex working populations who are working today, that it puts them in danger. So this is something that we can't accept.
So you all agree that there's nothing in this bill that you really like?
Exactly.
Okay. Let me ask you this question then. Could you give me some examples of the justification of paying for sexual services? You appear to be saying that not all Johns are bad. Could you further that argument that you appear to be making, that not only should the prostitutes be criminalized, but that as a general rule it would be an error to criminalize the purchase of sexual services in exchange for money, payment, or compensation, or consideration, as is used in the criminal code?
I could start addressing that, perhaps. Yes, I do believe that purchasing sexual services from a consenting adult should be a legal activity. Absolutely. I see nothing wrong with purchasing sexual services, much like any other kind of service, massage therapy, getting your nails done. But it's also a very, it can be very therapeutic for a lot of clients. They're not all wonderful people, no, but I'm sure, in here, there's probably people I think are great and some people that I think aren't so great, right? It's any group of people, you're going to get people you like and people you don't like, and who are nicer and not as nice, right? There's lots of people who are lonely. They might have disability.
I see.
Disabilities. Yeah.
I see. Could you elaborate on that?
Oh yes. There are clients who, because of their disabilities, seek out sexual services I know one woman who regularly visits a fellow who's in a wheelchair. And he's a regular client, lovely guy, but he wants some caring and attention, intimacy in his life. And they have a relationship, she's been seeing him for many years. I don't see why we need to deny that relationship. And then we also, to put it to the other side, there are also, people who, they just want to have sex. And if there's someone else who is interested in also having sex and would like to be paid for their time, I don't see the problem with that. Frankly, I don't understand why it's wrong.
Could you elaborate on it as well, please?
Non, c'est intéressant. Je suis en train de réfléchir.
No, it's interesting. I was thinking about it. At Stella, we see the diversity of people who work in the industry, and we recognize that our clients are also part of that diversity. They come from all social classes, professional experiences, just like us. One interesting thing is that in the bad clients list, which is a tool that everybody in the sex work industry uses, we see with that list who are the clients that hurt us. And I think that's the list, those are the kinds of tools that people should focus on. I said, for example, once that this client showed me no respect, they sexually assaulted me, and that we should do something. But the times where I had a consenting sexual service with the other person, we had our transaction, we had a contract, everything went well. There should be no problem with that. The Supreme Court clearly decided that said that perhaps we don't need to be in the bedrooms of the nation to understand what's going on, if there's money there or not. And clients might well be your fathers, your brothers, even your children, anybody in this society. And I hope that one day will not be clients that are criminalized for having sought out sexual services. Jailing people for having purchased a service from another consenting person offering them, like any other job, is nonsensical.
I think we really have to ask ourselves why we ask these kind of questions of sex work, why someone might want to do it, why someone is seeing someone, and we don't ask that of other industries. I think it would be really helpful to be able to identify two consenting adults, someone who's consenting to sell his or her sexual services, understand that this is not a forced relationship. We're not talking about force, we're not talking about exploitation, we're talking about a consensual situation here. So we can, I think, leave those ideas outside of this conversation as well. And I think it would be useful to compare it to another industry that we see as being intimate, maybe counseling, for example, maybe an artist, somewhere where there is also an extreme disparity in income between the two people who are engaging in this financial relationship. Here's an artist, doesn't make much money, is producing something that is potentially very intimate to them. It's their art. Someone is buying a piece of their experience, a piece of their soul, perhaps, as some have even described of sex work. So I don't know why those would be a term on which to base if they can or cannot engage in that kind of financial exchange. So I think we really need to examine our associations of sex, of women's sexuality, that we think she might not be adult enough to be able to consent to something like that, perhaps social fears around sex that we have and have been ingrained in our culture for a very long time. So I think this is in part about trusting women and sex workers who are not always necessarily women, and clients are not always men either. I think that's really important to kind of look at the diversity of the reality of sex work, right?
Yes.
And to be able to trust the person who is there as a consenting adult that this is something they want to do.
Senator Batters.
Thank you very much for being here. I want to go right to this topic of consent, because from what we've heard over the past 2 days and earlier this morning is from a number of people who I don't think we can discount. Certainly there's a wide array of views on this topic, but at the same time, I don't think we can discount the experience of some of these really tragic stories that we've heard, which, from my point of view in Saskatchewan, you hear a lot about those kinds of stories. And so I think that my point of view is that consent is affected by many factors: poverty, drug addiction, abuse history, et cetera, et cetera, et cetera. And so how consensual is that relationship really for the vast majority of prostitutes is what I would question. Also, what I'm going to ask you to comment on specifically about consent is, would you agree that consent is impacted by who is deriving the economic benefit of that transaction? Would you agree that there's a difference between a prostitute's ability to consent if only she herself is deriving that economic benefit, or if she provides some of her economic benefit or almost all of her economic benefit to her pimp or a madam or somebody like that, someone running a brothel? Would you agree that there's a difference in those two situations?
I would agree with you. I think when we talk about consent, we need to think about constrained consent and the choices that people make when there's only so many choices. And that's why I said in my opening statement that we need to increase people's choices, right? So, for instance, if you could advocate for a universal child care strategy where we have access to universal child care, I know how many sex workers I know that would help out. They wouldn't have to work as much. They would be really happy if you do that. If you created more affordable housing, that would be wonderful. They would be like, wow, maybe I don't have to see so many clients to pay for my really high rent in Toronto. Increase the minimum wage, because frankly, you can't live on minimum wage. Okay? Increase disability payments, welfare payments, right? So when at the end of the month the money runs out, you don't have to hit the street to feed your kid for the next few days till you get to your next check. And these, frankly, these are the realities. And so when this bill is decreasing those choices rather than taking these resources that would go towards Bill C-36 and enforcing this law, which criminalizes adult consensual sex work. We could take those resources and really help survival sex workers by doing those kinds of things. And then the other part of the question I can address a bit. Again, I think I would agree that I think what you were getting at was that someone working on their own independently has more control over their economic, their economic situation kind of thing, or that they have more economic benefit, something like that.
Do you see a difference between prostitutes who are working only for themselves or ones who have to pay a lot of their money to pimps and madams and people running brothels?
Right. Yes, I do see a difference between that. And I would compare it to, for instance, the constrained choice that, say, someone living in Bangladesh makes to work in one of these giant garment factories, right? Who are maybe getting paid a few dollars a day. It's dangerous work. The work conditions are terrible. They can't unionize. They don't have access to labor and legal rights. And yet there's a CEO of that company who is profiting from those people working in those factories, right? I think what we're looking at is a capitalist relationship, right? And I actually think capitalism causes a lot of problems, and because of the very problem that you're pointing out here, that we're constrained under capitalism to sometimes have to choose work that we don't necessarily need to choose. And so I didn't know you were anti-capitalist.
No, I'm
Wonderful.
definitely not anti-capitalist, but I would not equate capitalism to criminal activity.
And also, in terms of third parties, I do want to address the third party issue, right? I do think, I know people who went from working in an agency and to becoming independent. And when you become independent, if you're able to, because well, first off, lots of people choose an agency because they're new to the industry, right? So they want a kind of safer place to work. They're with other sex workers. They kind of learn the ropes from those people. The space is provided for them. They have a driver if they need one. All the advertising is done for them. And so for that, the agency takes a portion of their profit. It's similar to the artist example that my colleague here mentioned. Many artists have an agent or an agency, or, same with actors, who they pay to find them clients, and they do that kind of outreach and publicity work for them. And I see it as the same relationship. And in fact, by decriminalizing sex work, such as in New Zealand, there are labor laws, right? It's like labor laws that sex workers can actually access. For instance, there was a story just came out this past year, I believe February, where a young woman who was working in a brothel was being sexually harassed, and she brought the owner and the manager of the brothel to court for sexual harassment. And some people might say, well, she's a hooker. Of course you're going to get sexually harassed at work. That's part of the job. But no, the courts found that they're in the wrong, that no one, not even a sex worker, not a prostitute, or whatever you want to use, should be sexually harassed at work. And she won. She won a settlement of approximately $25,000.
Jump in there, Senator
Sure.
Zephyr.
Thank you very much. I want to first start with Stella. You have set out very clearly, you've answered 10 questions I read on this issue, and I would recommend my colleagues read your answers. But the one question that I'd like you to expand on, that we've heard a lot about, is there is a lot of talk around this table about reducing prostitution. And won't the laws that criminalize johns and pimps be a good thing because it would reduce prostitution? And can you say, would that happen if the laws criminalize the johns and the pimps? Would it reduce prostitution?
Nobody can make this. On peut pas faire cette assumption-là.
You can't make that assumption. If you look at what's going on in Sweden since they put in place these new criminal provisions regarding purchasing of sex services, we cannot see that prostitution has decreased or anything like that. All we do know is that it moves elsewhere. Everybody agrees to say that it's moved out of its usual locations. And people need to know that there are people who work in the sex industry, and these are people who will continue to pay their rent and continue to live in the society that surrounds them. So I don't see why we would like to decrease prostitution in and of itself. These are people who work and who are activists for sex workers' rights. The idea shouldn't be to decrease prostitution, but to increase the protection of our rights to life and security. I think, anyway, at Stella, we think that we should create communities that are safe for everyone, including sex workers. And I will repeat it, you are mistaken to think that attacking demand is going to reduce the need for women to work. And again, like my colleague said, we are not only women in the industry, there's a whole diversity of people. But regardless, we're going to continue to have to work. And throughout the criminalization of prostitution in the past, didn't decrease prostitution. We just had to work in increasingly worse conditions underground with all the repression and violence. But you saw that even with those criminalization laws, prostitution didn't disappear. We were still in strip clubs, we were still on the streets, and we are still here today. So sex work will not stop tomorrow morning because you passed Bill C-36. However, you can help us improve our working conditions and essentially put an end to stigmatization. I would never want my children to say to whoever it is that my mom still works in the sex industry. We cannot submit our children to that and have them carry that stigma of slut or hooker. And we have to consider sex workers as human beings. Thank you for your answer.
Both of you, Ms. McDonald and Ms. Matt, you know, one of the things that this bill and the minister made a different kind of presentation, Minister of Justice, here than he did in the House. And I've been really reflecting on what he's saying. But one of the things that there is an assumption in this bill that all sexual workers are victims. And, you know, there are, as are in life, sexual workers who are exploited. We accept that. Sexual workers that are trafficked, we accept that. But you are saying that there are also sexual workers that do this on a consensual basis. So obviously, given your testimonies, you disagree with the minister's fundamental assumption that all sex workers are victims. Would you agree with that?
Yeah, absolutely. We do disagree with that. I mean, we work closely with sex working populations, and I can tell you quite frankly, none of them identify as victims. They might be struggling economically. They have faced challenges in their lives. They've faced a great deal of discrimination and oppression. We live in an unjust society where some people have more options than others. And the response to that shouldn't be to criminalize the most marginalized and make their lives worse. It should be to help raise them up so they have more options so their lives can improve. This framework of victimization, in my opinion, really contributes to the stigmatization that sex workers experience. You know, it's the same kind of stigmatization that leads them to become targets for predators. You know, this idea that they are helpless victims who have nowhere to go and no one cares about them. What a more targetable population for violence. If we can change this conversation and talk about sex workers as agents, you know, as independent, capable individuals who deserve options, who deserve support, you know, I think that would really make a big difference.
Oh, I thought she was asking both of us that
Well, we
question.
have time limits, so
Oh, okay.
you'll have to wait for
Sure.
another opportunity.
I will give you the opportunity to put on your headphones. Thank you, all three of you, for your presentations. You have heard talk of the $20 million fund that the federal government will make available for community groups who will help sex workers. I also understand that this fund will help those who want to exit prostitution and rebuild their lives. So here's my question to you. How can this investment fund be best managed so that those people who need it the most benefit from it? Well, for us at Stella, we wouldn't simply fund exiting programs. In fact, the members with whom we work, with whom we've been working for 20 years, have not identified that as a priority for Stella. Our needs as sex workers in Montreal are very different from the one you're proposing of having an exiting program. This year, Stella is working on an anti-violence program that proposes a much wider-ranging proposition. We try to determine what kind of violence we're dealing with. Is it the violence of our boyfriends or girlfriends? Is it the violence of our pimps? Or is it the violence that's perpetuated by the system? Stella offers support no matter the violence that our members have seen. We don't offer them an exiting program de facto, but we support them no matter what they need. So this year, we have created an exiting program, but an exiting program from an abusive relationship, not from prostitution. People transition outside of the industry for a good number of reasons, whereas many others stay in the industry for a whole slew of reasons. And organizations like Stella, who don't have an exiting mission, if you will, from the prostitution industry need to be there to help sex workers and fight against exploitation, stigmatization, and violence. We can't offer sex workers nothing but exiting programs, because a good number of us will continue working for a slew of reasons, especially those of us who are drug users. We will continue to work. We can choose between stealing a piece of meat in the grocery store or offering a blowjob on the street. Those are the choices that we have before us as sex workers who are also drug users. But offering only exiting strategies is insulting to sex workers. That's not the need we have. Thank you, Ms. Couette. Ms. McDonald or Ms. Matt, you want to say something?
Just to say that the reality of sex workers' lives is not often represented in these more religious, moralistic exit programs that we're seeing. Rescue agencies don't recognize that sometimes sex workers might leave the industry for a while and come back if they have to, put a new roof on their house or buy school supplies for their children. So quite often a program that is framed solely around exit from the industry isn't going to be welcoming when she comes back and says, yeah, I'm doing it again now, can you support me? So we're really focusing on those is creating really unsafe environments for sex workers where they can't actually get support if they need it.
At Maggie's, we work from a harm reduction perspective. And that part of that perspective is about meeting people where they are at. So we offer services that are to sex workers, to youth sex workers, to male, trans, etc. sex workers that are not contingent on them leaving the industry. We will help people. If I speak with a youth sex worker, I will try to get them into affordable housing, which frankly there's not enough of. I will try to help them access certain things. I don't want to see kids working on the street, but we need to create more social, for homeless youth, we need to create more shelters, we need more accessible spaces. And the thing is, when we have a space like Maggie's, where sex workers know they can go and they're not, there's no underlying assumption that they are victims or that they're damaged or there's something wrong with them or they're icky, or that they're going to be try to pushed one way or another. They feel more comfortable coming. They come to us, right? So if a youth sex worker is worried, doesn't know where to go, they'll be reported or they'll be sent back to an abusive home, because many homeless youth are runaways. They want to go to a place where they can be actually assisted on the ground with what they're doing. Yeah.
Merci, Madame. Thank you for your testimonies. I have two questions. One first for Ms. McDonald. In your presentation, you have offered to come back on some sections of the bills that you feel would be damageable to persons who are involved into sex trade. Could you identify them quickly, because you seem to have a very clear perception of which section of the bills would be more damageable?
I don't have my specific notes, but okay, I've got some here. Well, for instance, the section 213, and there's been a lot of discussion this past week on section 213, which criminalizes communication. Well, that gives police a lot of power to continue to target and harass sex work. And if we want to make sex workers safer, because yes, sometimes we are victims of violence, right? Sometimes we are assaulted by a client or a predator posing as a client. Like many women, so there's statistics that say like 50% of all women in Canada will face sexual assault at least once in their lifetime. Some statistic like that. I believe it's from the Canadian Women's Federation website. But we want to be able to contact the police. But when we have laws like this, it just breeds mistrust and fear. it'd be great if, we could scrap the bill and use some of this 20 million to, re-educate police on how to really connect with sex workers, because that will help them if they're in coercive situations, or they have a bad date, or they are having their money taken away from them. They'll be better able to do that. Then there's a section about third parties. And criminalizing commercial enterprise around sex work, something like that. So with that, I was talking about the agency example. That means that a sex worker who might be new to the industry or maybe not, who chooses to go and apply for a job at an agency, that agency could, there's some really great agencies in Toronto, right? There are some wonderful employers. I know some of them, like, not well, but peripherally. And then there's some other agencies where the agency, they're not so great, like a little, like not the greatest people, and you hear horror stories. But if these were legal establishments and the workers there were able to access labor laws, the manager or owner couldn't say to them, well, I got to try you out first, right? Like, that's messed up. I was going to say something else, but that kind of thing should not happen in the sex industry, right? We need to create we need to foster better relationships with enforcement. We need to frankly protect sex workers, not push them away. And then by criminalizing clients, you criminalize the ability to, for sex workers to make money, which, we all need a job, we all need to pay our bills, so there's that part of it. There's also the part where it impedes our ability to screen our clients, right? And I talked about that earlier, that there's no perfect screening method, but like I said, it's something that we can use to practice safer screening techniques, safer work tips, and that's some of the information we provide at Maggie's. Is like, here's ways that you can screen clients, or like tell your friend I'll be back in half an hour, or do a safe call to a person, be like, I'm in this hotel room, I'll be done in 1 hour, or when you're contacting the client, he would need to give you his phone number or his name, or a reference from another person, and they're not likely to give you any information about themselves if they might be criminalized, because you could be an undercover cop. If you want to ask me about any other specific ones, I can go on, but I don't want to take up too much time. You guys probably have
things you may want to say. Senator Dagenet.
Second round.
Monsieur le Président.
Thank you, Mr. Chair. I'll give you the opportunity to put on the headphones. Now, C-36 is a bill that wants to criminalize those people who exploit women and children, who abuse them, and abuse them physically. So I'm going to say what I need to say. The right of sex workers to continue working will not be impeded by C-36. It will, however, limit where they can do it, in particular places where you can find children. Legalization of prostitution, to me, is not an option on the table here today. The same with asking all Canadians to monetarily compensate prostitutes make by offering their services. Without judging what sex workers are doing, they're not the only women who will have difficulty making ends meet. I'd like to hear you talk, among other, Ms. Matt, about any suggestions outside of legalization to put an end the existence of organized crime in the sex industry, and how we can help people get out of the industry, because that's what the bill is seeking to protect, those people.
First of all, I think it's important to it might have been a translation issue as well, but to just remind everyone in the room that we aren't talking about a legalized regulatory framework around the sex industry right now. We're talking about decriminalization, so just the removal of certain criminal elements that have put sex workers in danger. So I think there are a lot of assumptions that this might mean, certain kind of open spaces that are used in, like within a municipal context. And so I think we just need to be specific about what that means. The purpose of the Bedford decision was to keep women safe. It was to keep Canadians safe. So it was found that these three parts of the criminal code were putting people at risk, and it was conflicting with their charter rights. So I'm having a really hard time looking at Bill C-36 and seeing anything in that is going to remedy that issue. In fact, it just replicates the same kind of harms that we saw in Bedford. Almost point for point is almost the exact same thing we saw be rejected by the Supreme Court. So Bill C-36 is unfortunately not a bill that is going to help women who might experience exploitation in this business. If anything, it's going to make people who experience exploitation in the sex industry much further away from support. So that's quite unfortunate. And I mean, also, there are bills, as was pointed out yesterday, repeatedly, that apply to issues of exploitation. That is already illegal. Violence is still illegal. Assault is still illegal. Confinement is still illegal. All of these issues that we bring up that we associate with sex work are criminal acts in and of themselves. And what this bill is actually doing is criminalizing the consensual exchange of adult sex. And what that is going to do, and what we've seen working with sex workers at Maggie's on the front lines, is that it pushes the industry much further underground. Sex workers are going to continue to work in these increasingly dangerous situations. So if this government wanted to support women who might experience exploitation, this is not the bill to do it.
If I could give a specific example, is that okay? So at Maggie's, we have a weekly lounge that's predominantly attended by street-based sex workers. And we have different activities. Sometimes we do like how do you make your own website or like resume, whatever. And sometimes we just hang out and chat. And one day we were talking about the bill. And they were really concerned because they were saying, if I can't find clients on the street, like, how am I going to pay my bills? I'm going to have to work for some asshole who can find me those clients. Sorry, pardon my French. Sorry, that was bad too. Just put my foot in my mouth. Okay, so yeah, they are worried that they would actually have to work with criminals, with organized crime, with a pimp, in a more exploited relationship, because independently they won't be able to find clients. You know what I mean? Where are you going to get your clients?
I'd also like to just expand on that as well, the comment about organized crime. I mean, what we're looking at here is almost a replication of laws that prohibited alcohol. Prohibition era legal frameworks around access increased organized crime because it was so lucrative. So when you bring things out in the open, you can deal with formalized legal procedures, you can deal with labor laws. That's when people can actually access justice, they can access their rights, they can access safety.
Okay. Thank you very much. Senator McInnes.
Thank you very much. You're great communicators. And the great thing about the democracy we live in, we're all entitled to our opinions and divergent views. Government's intent here is to reduce those that are involved in the sex trade. And we've heard people speak about the Nordic model, that it works in Sweden, it reduced prostitution by 40%, and then we hear you this morning that says that it won't work, it drives the sex trade underground. But that's not what we've been told, and it's not what I'm sure the Department of Justice has researched. So the government's intent was to reduce those involved in the sex trade using the Nordic model. And why did they do that as a government? And we've heard it consistently here over the last 2 days. The horrific situations of individuals, youth, being forced into the trade, being forced to have sex, being addicted to drugs, and all of this. And so that's why governments that's why we have governments and respective departments to look after Canadians to the extent that they can. And so that's the intent, and that's what they are doing. With the utmost of respect, I do not believe that Canadians are ready to provide benefits directly to the prostitutes. Prostitutes are entitled, as any other Canadian, to the health care benefits, to social services benefits, whatever benefits come with respect to housing. They are entitled to that, and that is the way it is. So that's the intent, and to be candid, that is the responsibility of government. And I think in this instance, after what we heard, they are being extremely responsible in moving in this direction. So I respectfully disagree with you. But I want to ask you this question. You do not work to reduce the number of individuals in prostitution. That's a question. Or do you just help prostitutes that are in crises, that have a difficulty, a problem? Is that the goal of Maggie's and the others that are here before us? Is that your goal? Because you don't have in your job description or the setup of your organization, and I suspect there's a board or whatever, it's not there to reduce those involved in prostitution. Is that correct?
I can answer that. Maggie's is a small service organization. We're funded through the AIDS Bureau of the Ministry of Health. We predominantly provide safer sex and safer drug use education and materials to sex workers. We distribute condoms, needles, STEM kits, a variety of educational workshops, etc. Our job, what we do at Maggie's, is more than just, helping people in crisis. We also build communities. Like we build connections and communities between sex workers, because when we're together, we can share information about bad dates. We can use each other for safe calls. We can give each other tips. And you know what? Given that it's such a stigmatized and misunderstood occupation, it is so nice to hang out with other sex workers and connect. So that community is really important because a lot of people aren't out as sex workers. It's difficult. You face a lot of prejudice if you identify as a sex worker. So we do support, support current and former sex workers, actually, with their needs. Yeah.
Do you have a second part of that question, or do you want us to respond to that? Because I would like to respond to that.
Please.
Yeah, I think it's really interesting that a government's purpose is to protect its citizens. I think we can agree that that was something that you just suggested was a fact of why governments exist. That is not the same thing as aspiring to reduce the sex trade. Those are completely opposite things, in fact. So the intention of this bill, in our opinion, as people working directly with sex workers, is in complete opposition to the purpose of a government to keep people safe. This bill actually increases harm that sex workers and marginalized people are going to experience. So there's really a difference between the intent of a bill and the effect of it. I also want to just touch on the issue of Sweden. You mentioned believing that the Nordic model might reduce prostitution. There's absolutely no evidence. In fact, there is evidence that came out in, I believe it was 2008. It was a study by the police out of Stockholm, or out of Sweden, sorry, out of Stockholm. When the bill was put in place, the Nordic model, there were 90 massage parlors. Now there were upwards of 250. So it not only has it not decreased, it's actually multiplied threefold. It's just happening behind closed doors. Sweden is a place where There is no harm reduction material that is available because it is seen as enabling sex workers. So if you're a sex worker and you want to go and get some condoms so you can work as safely as possible, you are not allowed to do that in agencies like Maggie's, who offer support no matter where you are, no matter what you're doing for safety. We're not allowed to operate that same way. So it's turning a blind eye to the issues that really impact marginalized people, and it's putting an entire population at risk, in my opinion. Furthermore...
Can I just quick...
Senator Platt.
Thank you, Chair. I think I heard in your response, Ms. Matt, that you agree that it is government's job to at least try to keep Canadians safe. And I think we need to all agree that we may disagree with how that is done, but I think we need to agree that that is the intent even of government. The first paragraph of the preamble says, whereas the Parliament of Canada has grave concerns about the exploitation that is inherent in prostitution and the risks of violence posed to those who engage in it. So I think we want to make our streets and our cities and our towns and our villages safer. And we need to try to find a way of doing it, and we can respectfully disagree. My question to Maggie, and possibly even to Stella, is twofold. Ms. McDonald, you shared a little bit about what you do at Maggie. I didn't hear in there that you do counseling. So I guess my question is twofold. Do you have a percentage of youth that you have there? Because again, we were constantly talking about sex between two consenting adults. And yet earlier in your testimony, Ms. McDonald, you did refer to youth. What percentage of people under 18 are there in your organizations that you work with? And if you have that, do you at least counsel the youth to find a different occupation or work with them to find a different occupation, even if you don't with adults?
Our mission at Stella is a feminist non-directive approach. We don't tell the person what's good for them. What's good for you might not be what's good for me. We're all different people. Stella's other mission is a little different perhaps from Maggie's. We deal with adults in the industry because in Montreal there is already services for the youth in the sex industry. Even though when we walk the streets we see young sex workers, we refer them elsewhere. We hear them out, we listen to them, but anybody we meet, we offer a variety of resources, and counseling is part and parcel of that. We do active listening exercises, and we refer to people where they need to go, but we also listen to them, no matter what they need to say. We are funded as well by the Public Health Agency in Quebec, but also by the Public Safety Ministry in Quebec. Because we prevent violence very well, and we also support sex workers very well in what they need, and by creating accessible services without any discrimination. And yes, of course we offer counseling services. Though the people who work at Stella are in constant training. From the moment they arrive, they know the industry that they are working in because they come in large part from that industry, and they have first-hand knowledge. They know exactly what they're talking about, you see. And I will let my colleague continue on this point. Yes, of course we offer counseling. We give people want to know what their options are, and what the options are we can offer them, but we don't pick for them what their options are.
Whether you have statistics on the number of youth.
Okay, sure. I would love to offer counseling at Maggie's. The fact is that we have two staff members. There's myself, who's does most of the administrative work, and then there's our outreach worker. So, I mean, if we could have more funding to employ counselors for the reasons you're suggesting, I would please, maybe we can chat afterwards. That would be great. You can pass me on your card.
I don't pass out the money.
If you, well, you can maybe give me an idea. But anyways, yeah, oops, sorry. What we do, though, is a lot of referrals. So we refer people who come to us who might need help with housing or job training, counseling. We have a list of sex worker positive counselors that we can send them to, so we know they're being sent to a safe space. And I think it's also important, I think, for me as working for, to reduce HIV/AIDS. You probably heard that the World Health Organization released a report recently saying that the #1 way to reduce the spread of HIV/AIDS across the globe is to decriminalize prostitution, homosexuality, and drug use.
I would like to know how many young people you have.
Oh, right. Currently, we don't work with any youth at the moment. We did have a program for youth a few years ago. That was before I was there. I am going to be presenting, doing 2 different workshops. One is with an organization for LGBTQ youth, and I'm doing that in coordination with a lawyer from, I think it's called, it's like oh yeah, sorry. Anyways, it's like a legal clinic that's specifically for children and youth. So, because we've been asked by community organizations to go in and help them out, there's another organization that contacted us to do a workshop because they want to find out how they can help the youth that they are working with.
Thank you.
Thank you, Mr. Chair. Ladies, thank you very much. I'd say your testimonies are very clear, your positions likewise, and I respect that. I'm going to go down the same way that the Senator McInnes went. We know that prostitution, regarding prostitution, Canadians have essentially crystallized positions between criminalization, or at least partial criminalization, of Johns. We have heard from groups that are in one or the other of those camps, and the law has to represent not only the view of one group or the other, but the views of the whole of communities across Canada. So obviously, liberalization of prostitution is impossible, and full criminalization is also impossible. So as legislators, we have to find the middle ground that's acceptable to both the women who work in that industry, but also for Canadians who ask government to manage their interests. There are groups who have told us that total liberalization is going to make things much worse. You're telling us that criminalization is going to make things worse. So when you're in our shoes as legislators, how do you find a compromise so that you can continue practicing your business in all safety, but we also can't go all the way down to liberalization, which seems to be in part your approach? Well, I find the Supreme Court's Bedford decision extremely interesting as a starting point for an approach, how we need to work with people in the industry, as much those who have negative experiences as those who have a positive experience in the industry. And it doesn't matter what that means. We are working for money, not to have pleasure, even sometimes, even though it might be interesting and pleasurable. And I'm sure you too have those kinds of moments where it's much funner to debate than others. But I can tell you that criminalizing people in order to protect others is nonsense. Well, but the Supreme Court does not vote in laws. It interprets laws that Parliament adopts. So we can't say simply because the Supreme Court made a decision that we're going to decriminalize. The Supreme Court said, redo your homework, and that's what we're currently doing. And we're redoing our homework in accordance to what the wishes of the population that voted us in are. We are elected, you are appointed, you have to create laws that create consensus in the Canadian public, somewhere between full decriminalization and a form of control of criminal activity in this field. Well, let's criminalize those criminals who commit criminal acts like violence, and let workers work. It's like saying, criminalizing, as my colleague said, people in an industry like the garment industry that has workers working in exploitative conditions. Let's just jail everybody, and then we just solve the problem of the garment industry. No fuss, no muss. But that's not reality. The reality of sex workers, and of all workers, is to have the rights that all the other people in society have. I don't want to see my mother or my children jailed simply by the fact that they do sex work, even though people have a hard time understanding why sex work is even undertaken by people in their lives. I would hope that legislators will consider that those people who are in the industry are human beings like anybody else, and they are in the industry for one reason or another.
For a second round, and there has been some interest expressed. We'll begin with Senator Baker.
So you were particularly opposed to Section 213 in this bill, which will criminalize you if you impede the flow of a pedestrian or an automobile or attempt to stop or in a public place or in a place that can be viewed by the public. That's the first section of 213. The second section has been changed to communicate in an general area where children may be present. So you're particularly concerned, you want that removed because that criminalizes the activities of a prostitute. And am I correct in saying the second thing that you will also oppose are the increased sentences on those who purchase sexual services? And your message is that not all people who are termed as Johns, although we have men and women who purchase sex in Canada and throughout the world, that not all of them are bad, and that you provide a healthy service that should not be criminalized. Is that a good capsulation of what you're saying?
Yeah, we oppose the criminalization of the buying of sex because it's been shown in many countries, and here in Canada. I mean, prior to the Bedford decision, it was illegal to communicate for the purposes of prostitution, even if you were selling or buying. It was illegal to be found in a common bawdy house. So, I mean, there have been criminal charges that have applied to the purchases of sex before. And what we're finding is that those put the most marginalized women further at risk. So that is why we oppose those. Similar to the question that was just asked, this isn't really a matter of opinion. It's a matter of basic human rights and a right to safety and security of the person. And when you find that a criminal law impedes the safety and security of a person, as we're finding with a law that criminalizes the purchasing of sex and communicating ways that sex workers use their safety mechanisms, it's unconstitutional.
I think, though, an aspect that we haven't heard much of is the fact that you provide a service to some people who actually need the service and who should be recognized as it should be recognized as a legitimate service for that particular person.
There's nothing inherently...
We haven't really gone in, we haven't really gone in. Right. You've given some examples, Ms. MacDonald, which I appreciate, and we haven't heard much about that. You know, the assumption is made that all persons who purchase sex are bad, and that it's not a healthy thing to do.
Yeah. I mean, I don't think that the purchase of sex should be criminalized whatsoever. I don't believe that purchasing sex is a violent act. I think that assaulting someone, raping them, beating them, those are all violent acts, and sex workers should be protected from those violent acts. But, if I'm consenting, no matter what the constraints of my life are, if I'm deciding to do this work, I should be able to do that with whomever I choose, whether that's the fellow in the wheelchair or the guy, who's wants to hang out for a bit and go for dinner or go away for the weekend, or frankly, a guy picking me up on the street who wants to just go to the parking lot. So I think it should be my choice to decide who I want to see and who I want to sell my sexual services to.
First of all, wanted to clarify what, near the end of the last panel, Senator Baker brought up something about this 213.1 public communications section. I think he, at that point, was thinking that it was a lot more broad in application than it was, and that particular, then I gave my response, but it was not correct in that regard. And what I've found since then is that particular part that he was referring to, and he just referenced it right now, was 213.1 A and B. That's the part that talks about impeding traffic, and Senator... Yes, okay, or pedestrians. But it's not referring to the blanket prohibition, so I just wanted to make that clear for the record, and it's 213 sub 1.1, that's the new offense of communicating next to a playground, that sort of thing. So that previous section Senator Baker was referring to, it already exists. It's only being modernized by removing the word prostitution. So I wanted to just clear that up. I wanted to just quickly ask the representative from Stella if your organization promotes programs which facilitate creating relationships with police, because we've heard that this is really important in getting vulnerable women to report violence and increase their safety. And I'm wondering if you do that, or if you don't currently do that, would your organization consider working on that?
We're working on that since 20 years now. Created a relation with police, it's really complicated. Vous savez pourquoi? Parce que on est...
You know why? Because we are always considered, even today with the bill, as victims. Police don't take into consideration what we do. It's also very difficult for cops to think of our needs when they're there simply to enforce the law. We have several contacts. I can talk to you about something that we do for the police service of a specific neighborhood in Montreal where there's a lot of street prostitution, and in which the levels of violence against my colleague sex workers are staggering. And the global community and the sex workers community were very worried about this, so we worked alongside the community police service there in order to make it easier for sex workers, provide them with a helpline, a tip line, indicating where they were attacked and who was the person who attacked them. And you know, when a sex worker gets attacked, they tend to run away and hide. But through the work that we did with Stella and the community police module, we gave sex workers the opportunity to have a helpline, call the cops, and determine who the people are in the neighborhood who are abusive to sex workers, and get the information directly from sex workers in order to identify them and then put an end to the violence that sex workers are under. But it's not everybody who's comfortable with this. We are still working very hard with police officers in neighborhoods where it's difficult to get them to understand that the work that Stella does is essential, which is very far from what police services do often, which is enforcing the law and repression. We try to frame it as a case of protecting human rights. So yes, we do a lot of awareness. We even offer training for future police officers who are in the academy. We do all those kinds of things. We have even helped train judges and educate a lot of people who help enforce laws. And we believe at Stella that people need to be aware of sex workers' realities, specifically to put an end to the violence against sex workers, and give the straight story about what sex workers go through, and not allow people outside the industry to get that narrative. We want the issue of sex workers and the cases of sex workers be advanced.
Your responses to these questions. We are running out of time. I'm going to go over a little bit because we started late, but again, witnesses try and tighten those responses up. Senator Jaffer.
Thank you. I just want to clear something that so I don't leave a misimpression, is that I understood that the Supreme Court did not tell Parliament to rewrite the law. They just struck down the law. And we could decide not to do anything. So that's my understanding of it. What concerns me is that I feel, reading the whole of Bedford, and I've said this many times here, what the Supreme Court says is makes no difference that the conduct of pimps and johns is the immediate source of harms suffered by prostitutes. The impugned laws deprive people engaged in a risky but legal activity of the means to protect themselves against those risks. The violence of John does not diminish the role of the state in making a prostitute more vulnerable to that violence. Are you all saying that the state has a role to keep you, make sure that you all are protected in the work you do?
Absolutely. I think that's extremely well put. The government has an obligation. We all have charter rights, regardless of whether we're lawyers or senators or sex workers. And, that's exactly what we're asking for, is our right to safety, security of the person under the charter. So, my colleague has mentioned it about marriage. Being married to a man is extremely dangerous. It is the highest risk factor for women in this country. To be in a relationship with a man, are we asking, do we think it would help them to make marriage illegal? No, it's definitely going to make people's lives worse, and that's what we're seeing now, absolutely.
Thank you.
Okay, thank you. And the last questioner, Senator Joyal.
Madame Cahouette, hier, nous avons...
Thank you, Mr. Chair. Ms. Cahouette, we heard from Valerie Scott yesterday, who was one of 3 appellants in the Bedford case, and in her brief she said the following. In 2001, the City of Montreal adopted a sort of version of the Nordic model. It dealt specifically with the Johns, and in the 3 months following the implementation of this new approach to prostitution in Montreal, you, Stella, are mentioned by name here, saw a 3-fold increase in attacks in violence towards sex workers, and a 5-fold increase in attacks with a deadly weapon. Can you tell us more about this information that Ms. Scott submitted yesterday in her brief? Yes, that's perfectly accurate. What we've seen in Montreal since the police put in place the Cyclops project, but also this great big sweep of prostitution johns. Of course, they're not attacking the sex workers, but they are, in a way, indirectly affecting them. And what we see in Montreal shows us exactly what the impact of a Nordic model of criminalization of clients creates. Clients disappear from a specific area because they've all been arrested or pushed out of the neighborhood, and all you find there are people who have already dealt with the justice system, who have nothing to lose, who are already known by police officers, and who are known specifically for having attacked us. So we are at a higher risk. When John sweeps in Montreal neighborhoods occur, sex workers move out, and you find them working in industrial parks very far from your usual areas. When there are those John sweeps, we can't work in group because we are more visible to police officers, and our bad clients always talk about the kind of violence that we see in a specific neighborhood. And because there's impunity for the abusers, we see an increase in the violence. And I was in a citizens meeting recently, and I was working with the sex workers module at the community police operation. I was telling the citizen that they don't arrest sex workers because they respect the sex workers' integrity, and but people are not comfortable with criminalizing Johns who are not doing necessarily anything wrong. And they think that what the cops should really focus on is arresting the true criminals.
Witnesses, thank you all for your appearance here today and your testimony. Very much appreciated. And members, we will suspend until 1:30. please. Welcome back, members and witnesses, and to those watching these hearings on television. And for our next panel, let me introduce Maxime Desrochers, who is here as an escort for women, Tyler McGarry, street worker, sex workers program, RESO, Chris Atchison, who's a research associate with the Department of Sociology for the University of Victoria, and Constatia Spooner, a representative of the Coalition of Body Rub Parlors of the Greater Toronto Area. And I understand you all have opening statements, and Mr. Desrochers, we can begin with you.
Thank you very much. Bonjour. Mon nom...
Hello, my name is Maxime Desrochers. I am 40 years old. I started off with a bachelor's in computers. I worked there for 10 years, and then I became an escort for women. When I say I like my job, many people are surprised, and yet I am not the only one in this industry who feels that way. A good number of my colleagues, both men and women, like their job. Like any other job, we do it for the money, but for a good number of us, it's also because we enjoy it. Unfortunately, to come out in public like this often leads to stigmatization. And stigmatization is actually a phenomenon that Bill C-36 will only worsen because the bill is going to so intimately tie together crime and prostitution. You have already heard over the past few days from lawyers here about the anti-constitutionality of this bill, so I won't dwell on it. But I would like, however, to tell you that in the past, the Canadian government declined to legislate the sexual practices between consenting adults. I think here of the case of homosexuality. And in the case of abortion, the Canadian government decided not to legislate women's right of controlling their bodies. So I think it would be inconceivable to legislate the way in which men or women practice their sexuality. Now, those who support Bill C-36 say that Bill C-36 will do wonders for the good of women. Well, by doing that and having that as a goal, you remove the right to self-determination by women. It's saying essentially to my friends and my lovers that they don't have the good sense necessary to practice their sexuality as they see fit. It's to tell my clients that they do not and will not benefit from my presence because they are criminals. Furthermore, it's to essentially deny that men like myself or others practice the oldest profession in the world, and I can tell you that we do represent a good number of people. And overall, Bill C-36 will also lead to greater expenses in police budgets in order to enforce the bill. And it will also cost more for the legal system. And all of these expenses are going to be paid by Canadian taxpayers. And at the end of all this, the Supreme Court is going to give us, is going to decide on our side. Of course, it's going to be a very long and protracted battle once more, but I can tell you that we're going to win. Personally, for myself and many others in the sex industry, C-36 represents lost income, and I'm already feeling the effects already. The moment that the bill was presented by Mr. McKay, imagine losing up to 75% of your income from one day to the next. You can understand what kind of precarious position we find ourselves in and what kind of stress it creates for us. We don't know if we're going to make ends meet at the end of the month. And finally, what I'd like to say is, as a group, our clients, men and women, are not perverts, are not criminals. They are human beings like just anybody else. And we are not victims. We simply need society to support us, for police to support us, in order to create a safe environment for us to do our job. Unfortunately, Bill C-36 goes against all of that. It is not a tool that will help us. It's a tool that will lead to greater expenses and that will further marginalize sex workers. Thank you.
Thank you. Over the 17 years of existence, the male sex work program of Réseau has continued to offer frontline health services and social support to male sex workers in Montreal. In general, there is relatively little focus on the realities of male sex workers in the discussions around sex work. Réseau feels it's important to highlight that criminalization of sex work will have a direct impact on the health of the men working in this industry as well as their clients. The laws that criminalize certain aspects of sex work limit access to essential health and social services for male sex workers, such as sexual education and testing for HIV and sexually transmitted infections. For those who are already living with HIV and hepatitis C, this can limit their access to proper support and treatments. When following a treatment for either one of these, an adherence to a strict daily routine of medication is important to ensure the success. When sex workers are criminalized and spend more time being arrested and being incarcerated, gaps are created in their treatment plans, which directly diminishes their effectiveness and the health of the person. The same applies when sex workers can't access medical institutions, pharmacies, community organizations, or even their own homes due to legal conditions that are imposed on them after they're released from prison. The criminalization of clients will also create environments of stress and fear for both the clients and the male sex worker. Clients will have to search for sexual services in more isolated areas, and in turn, the male sex workers will find themselves working in these areas where they risk their safety and lack control over their work environment. When the process of selecting a client is rushed, it is harder for a sex worker to evaluate the potential danger, put in place measures of protection for themselves, and to negotiate safer sex and condom use. If the use of different tools for advertising and communication, such as the internet and classified ads, are also criminalized, then a similar environment is created where there lacks the necessary space to negotiate an equal and respectful encounter. Many clients of male sex workers may also be going through their own coming out process in regards to their sexual orientation. They often will be struggling with both external and internal homophobia. Criminalizing their experiences creates stigma and reinforces the fear they experience. This further isolates these clients in their difficulties, as well as limiting their access to health and counseling services. When clients are less able to access services for their well-being, then there's a direct impact on the health and safety of the male sex workers that they frequent. Thank you.
Mr. Atchison.
Thank you. I'd like to speak to 3 issues today, and I'm speaking about these issues from my position as a researcher. I've been researching people who purchase sexual services for 20 years, but I'm also speaking as a research methodologist, which is part of my profession. The issues I'd like to look at or talk about briefly today are limiting advertisement and communication of sex workers and clients, using the law to prevent people from purchasing sexual services, and the research methodology that underlies much of what has been presented to you. On the issue of limiting advertising and communications of clients, well, the communication provision that was struck down in the Bedford decision primarily affected people who were involved in exchanges on the street. The communications and advertising provisions of Bill C-36 have the potential to extend the noted dangers to people who work in off-street environments, and by doing so, make it much more difficult for individuals to ensure their safety. The results of my research over the past several years have focused specifically on the effect of criminalization of law, of uncertainty around the law, on the transactions that clients have with sex workers. And what I've found on the basis of this research is that clear and transparent communications between sex workers and clients resolves much of the potential for conflict. When communications are hurried, when individuals are worried about being arrested, when individuals are worried about being outed or stigmatized in any way, shape, or form, when they tend to restrict their identity, they tend to be much more hurried in their conversations with workers, And that leads to miscommunications, uncertainties, which leads to conflict at one level. And that conflict can manifest itself in economic conflicts, i.e. robbery exchanges, or it can manifest itself in the occasion on violence. And this is primarily due to the fact that people are forced to interact in very uncertain environments. But on another level, and something that we haven't heard in these testimonies before you, is the effect that it has on sexual safety, sexual health practices. When transactions are hurried, when people don't have the opportunity to communicate clearly about their expectations, about what they're willing to do, their boundaries, and what the services that they're exchanging, the likelihood that they will use sexual safety practices gets reduced. The hurried transactions leads to careless sexual safety practice, and that has a tremendous impact for the spread of HIV and STIs, which currently are not a problem in much of the Canadian commercial sex marketplace because of open communication. But when we look at other areas around the world that are criminalized, they're very much a problem. On the issue of using the law to prevent people from purchasing sexual services, the law is a blunt instrument. It has limited effect when it comes to general deterrence, i.e., you cannot change social attitudes by simply passing laws that say you must behave in this way. There are two types of deterrence that we look at from a criminological point of view, general and specific. On a general level, law is meant to pass a message to the wider society, the general public. Now, in theory, this is great, you know, that we have these laws, everybody knows about them. But what I haven't heard coming out of Bill C-36, and I don't see anywhere in Bill C-36, is how people are supposed to learn about these laws. Is part of the $20 million going to a massive education campaign for all of Canada? If so, how much of that money? At a level of specific deterrence, i.e., does the law deter people specifically? Then we get into the issue of enforcement. In order to enforce the laws against people who purchase sex, law enforcement are going to need to quadruple their current efforts and probably multiply their budgets infinitely. So the assumptions seem to be that we can curb this demand by simply doing this. The other aspect of this is there's no provision that I've seen so far for education of people who purchase sexual services under Bill C-36. It seems to me that simply going out and arresting people doesn't actually teach them what it is that is supposed to be wrong with their behavior. I'd like to conclude with what I think are very important issues, and that's issues of methodology. Now, we need to pay attention to three things. First thing we need to pay attention to is the samples that we're relying on when we talk about the sex industry and the people involved in it. Most of the research conducted on the industry focus on the smallest segment of the industry, i.e. street-based sex workers. By my calculations, the majority of Canadian published research looks at street-based or survival sex work. And we know that that makes up 5 to 15% of the entire industry, which means that we know very little, comparatively little, about the 85% of the industry that exists off-street. Most research accounts presented before the committee come from very small and selective samples. People that are presenting you will talk about their experiences with their small samples or their own life experiences. While this doesn't negate the truth of these accounts that you've heard, I would encourage you to pay attention to the people and groups who are not represented in these hearings, so you're better able to understand the experiences and the truths of the diverse range of people involved in Canada's sex industry. The other issue is issue of how we define and measure things. Within the academic ledger, and certainly within much of the testimony that has been presented here, and at the Justice Committee hearings, no attention has been paid to what we actually mean by terms such as violent, or inherent, or exploitative, or even sexual services. If we don't know what we mean by these terms, how do we know that we're all talking about the same things? And more importantly, how do we know what we're measuring?
Ask you to sum up, please.
Okay. And in conclusion, the samples we use and how we define and measure key issues have direct implications on our ability to generalize findings. Many of people have spoken before you have attempted to extend their conclusions beyond what their samples actually allow. Attempts have been made to compare conditions and legal approaches in countries that have social, political, legal, and economic systems and conditions that are very different from the ones we have here in Canada. I'd encourage you not to continue to see the sex industry as simple. While I appreciate that some of you might want to bring an end to the commercialization of sex and sexuality, I do not believe that Bill C-36 will accomplish this.
Okay, thank you, sir. Madam Constadia Spooner. Ms. Spooner, please.
Yes. Thank you, Mr. Chair. I welcome the opportunity to speak with the committee this afternoon. My name is Constandia Spooner. I'm here representing a coalition of licensed body rub parlors in the Greater Toronto Area. I started in this industry when I was 23 years old by choice and became a co-founder of a facility 2 years ago. Our coalition has studied the bill and would like to state that we are not in favor of the bill as written. We must accept that throughout history, sex work has never been eradicated anywhere under any type of legal regime. I believe the government's main focus should be to ensure that participants in sex work are not exploited and to keep such activities away from residential areas. That is why I am surprised the government has taken the approach to target body rub parlors, as they provide many benefits which align with these objectives. Body rub parlors have been licensed by municipalities across Canada for decades. These regulations allow for their employees to work in a clean and safe indoor location. The licensing process requires owners and employees to undergo criminal background checks to ensure underage persons are not employed and people with serious criminal convictions are not involved in these establishments. Municipalities also have strict zoning requirements that ensure that our facilities are located in industrial areas. In addition, we must comply with building codes and safety bylaws. Furthermore, our facilities have an ongoing relationship with local police, which allows them to interview workers to ensure they are not being exploited or working under the influence of drugs and alcohol. For example, my facility collaborates with the local police to raise awareness of sexual exploitation and to provide an avenue of support to potential victims. Our coalition is concerned that Bill C-36 will negatively impact sex workers across the country. I would like to first point out that not all sex work is the survival sex work that has been extensively presented at this committee as well as the Justice Committee earlier in the summer. My experience both as an employee and now as an owner has shown that the vast majority of massage parlor employees work in this industry by their own free will. These women make a conscious and economic choice to work in this industry because of the opportunity to earn a vastly higher income than they would be able to elsewhere. Such a decision is no different than someone who chooses to work outdoors in a Fort McMurray winter to move ahead financially in life. Specifically, we are concerned that potentially criminalizing massage parlors and their clients will force these operations into more dangerous environments with a client base who are not afraid to break the law, both of which will increase the danger to people who work in this industry. I would like to point out that the same conclusion was reached by the French Senate in June of this year when they struck down a similar provision in proposed legislation. In conclusion, I would like to ask this committee to consider two reasonable amendments. First, Section 286.11 should be changed to only criminalize purchasers of sexual services where they should have reasonably known that the sex worker was being exploited, similarly to what is in place in the UK. Secondly, Section 286.25E, pertaining to commercial enterprises, should be amended to only criminalize such enterprises which knowingly exploit sex workers to derive a material benefit. We believe these proposed amendments will more closely align with the stated objectives of this bill by separating exploitative and non-exploitative activity. Thank you, and I look forward to any questions you may have.
Thank you all for your presentations. We'll begin the questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and thank you to the witnesses and the presenters here today. These are very interesting presentations that you've made that we will, of course, take into consideration as we examine this bill. Let me start with the last point that was made concerning, and we appreciate that you've suggested 2 amendments to the bill, specific amendments relating to the definition of sexual services. Now, we asked the department what the meaning, why they didn't define sexual services in the bill. And the response was that the definition of sexual services is adequately being provided in existing case law. What is your reaction to that statement by the department, and how do you interpret that?
Well, you know, there's difficulty in offering a service when you don't know if the service that you're offering is legal or illegal, and where is that line drawn? You know, I'm here representing body rub parlors. I am in agreement that this bill is not going to do what it's set out to do, other than criminalize prostitutes, and if not prostitutes, then the establishments that they work for and the people who seek their services. Now, all this will do is endanger women even more, and there's no definition of sexual service at this time. So these women often work under conditions and they don't even know, you know, what is legal, what isn't legal. It's a very flawed system right now.
There's a lot of case law, to my memory, in which the police go in and pose as clients to body rub parlors.
Yes.
And I read a lot of these judgments over the years as to whether or not a sexual service was being provided in these parlors. Your point, though, is that you are asking for an amendment that is reasonable in that the establishment itself would not be held liable for any illegal activity that took place without your knowledge. Is that your point?
No, we take responsibility for the people who work for us and the actions that they perform. I guess the bigger issue is that we want to distinguish that if we have an establishment and we have women working for us, that it is, you know, there are already regulations in place that ensure through the licensing process that we do not hire anyone under the age of 18. That, and I personally do not hire anyone under the age of 21. And they have to have a criminal background check. They must be legal to work in Canada. That in itself helps mitigate a lot of the issues with, you know, drawing girls into the industry that are being exploited. You know, there's thorough interviews that I conduct with young women before I hire them to ensure that they are there of their own free will. And there's certain questions that I ask which help determine that. So I guess my bigger issue is that as an establishment, I don't want to be criminalized for having a business that employs these women because, you know, under this new bill and depending on how the court defines this legislation, you know, I could be seen as a madam or a pimp. And unlike madams and pimps, we do not receive any money from our girls. The customer pays a door fee when they come in, and then there are services that are posted, massage services, which are posted in the room. The girls can only offer posted services, nothing above and beyond that.
I see.
And any gratuities they receive are simply because the customer enjoyed their service, not because there were additional services offered. We do not get any part of what is paid to the girl from the client. And we also have no outside involvement with these girls outside of them working for us. Unlike pimps who keep a tight control over their girls, inside work, outside work, we have very limited contact with our staff outside of work. They're free to live their lives. They're very independent women. They have other jobs. They go to school. They have their own businesses, many of them.
So we will question the officials when they come back. I'm sure all committee members will agree to do that to make sure that your legitimate concerns are understood in the legislation, if not in changing the legislation. I'm sure that the government doesn't intend to criminalize activities, or they shouldn't intend to criminalize activities that should not be criminalized, and we will check with the departmental officials as to their exact definition of these services or propose amendments.
Because our concern is that in the Justice Minister's own comments and the government's technical paper has specifically targeted massage parlors and strip clubs.
Yes.
Massage parlors have been named in this legislation. We would not be here today, perhaps, if that were not the case, but they specifically named massage parlors. Meanwhile, we work very hard with our municipality to ensure that our staff is very well, it has safety and are working in a secure, safe environment, zoned away from schools.
And licensed.
And licensed. And
Yes,
licensed,
yes.
correct.
Thank you. Thank you.
Thank you.
Senator Batters?
Thank you all. Thank you to all of you for being here today, and to Tyler and to Maxime. I just want to say that because prostitution is more typically men buying women's services, it's unfortunately too easy sometimes to overlook the presence of men and boys as a commodity in this industry. And so thank you very much for appearing here today to bring that to our attention. And you offer a perspective that I don't think the House of Commons Justice and Human Rights Committee heard, so that's something that uniquely the Senate is bringing today. I wanted to ask a question to first of all, Mr. Atchison. When you testified before the House of Commons Justice Committee in July, you went into a little bit more detail, so I reviewed that about what your particular research found and your methodologies and those sorts of things. And so just so that I'm understanding correctly, it's my understanding from rereading your testimony is that you do research with what we would think of as Johns, people who purchase sexual services. And those are, you referred in your House of Commons testimony to, you did 2 projects, you said that there were 50 in-depth interviews and 2004 surveys. And also at the House of Commons, you talked about, it sounds to me like your particular research that you do is these purchasers of sexual services, they self-report to you their experiences with prostitutes. And so I just quote from what you said to the House of Commons Committee, quote, in terms of their instigation of physical violence, less than 5% of the clients in your studies have presented or admitted to, basically, physical violence in varying forms. So it's a self-reporting mechanism, and is that correct?
Yes, no different than the self-reporting mechanisms that are used to gauge the violence that's experienced or perpetrated by people working in the sex industry.
Right, but you're asking the people who are alleged generally to have perpetrated the violence as opposed to the prostitutes who might have been experiencing the violence. Is that correct?
Could you clarify your question, please?
So your research is, your in-depth interviews and your surveys are not generally with the prostitutes, they're generally with the purchasers of sexual services, correct?
I've done research with all parties in the sex industry over the past 20 years. My particular focus is on people who purchase sexual services, not just quote-unquote Johns, which I'll add is widely seen as a derogatory term these days, and also camouflages the diversity of the people who are involved in purchasing sexual services because it presents these individuals as if they are all Caucasian, heterosexual, typical males, and they're not.
Okay, so the 2 projects you were talking about to the House of Commons, 50 in-depth interviews and 2,000 surveys, what percentage of those were clients and what purchasers, and what percentage of those were prostitutes?
Well, that was the second study was part of a larger study called Understanding Sex Work, where my colleagues and I looked at all aspects of the industry. Sex workers, of which my colleague, Dr. Cecilia Benoit, had 267 interviews. We also looked at managers, owners, and operators of commercial sex venues in 6 major cities. And we looked at regulators, policymakers, police. We looked at intimate partners of sex workers, and we looked at clients.
Do you know what the percentage was of what percentage was purchasers of sexual services and what percentage? I'm just trying to get a sense of whether someone's self-reporting, because I noticed that the chair of the Justice and Human Rights Committee asked you whether you follow up with if there's a matching process, right? Do you follow up with the person that they apparently bought the sexual service from to find out if that particular purchaser is telling the truth, or, if they were violent or if they weren't violent in that situation, and you answered at that point that at this juncture that would be impossible. So I'm just trying to find out how much of a potential methodological problem it would be, the self-reporting aspect of this research.
Like I say, no more of a methodological problem around self-reporting than we see with the existing research on sex workers' experiences within the industry. You seem to be asking whether or not we should have a double standard of acceptance of the truth of somebody's claim just because of their status as a purchaser or a seller of sexual services. And, as a researcher, I find that peculiar. I go out into these spaces. I construct elaborate methodologies for data collection, either survey, interview, and in addition, you overlooked the fact that I've also done hundreds of hours of ethnographic observation in various settings. We construct these methods out of existing and tested social science and health and social science measures. And we do a lot of work validating, cross-checking people's accounts. We attempt to look at how those accounts compare and contrast with people in the industry. The question about whether or not one follows up with a particular sex worker or with somebody's intimate partner, I thought was rather interesting, because it wasn't a question that was ever asked of anybody doing sex work, research with sex workers. Nobody said, oh, did you go and track down the client to get her or his side of the story? I mean, it seems to me like there's this kind of interesting double standard in terms of what it is that we're going to accept as truthful evidence.
Senator Jefford.
Thank you very much, Chair, and thank you very much to all of you for being here today. I first have a question for Mr. McGarry and Mr. Drusha, and my question is, I don't know if you've had an opportunity to read or hear what the minister had to say at the Senate hearings. Did you have a chance to hear that?
A bit, yes.
It was my perception that the minister was under the impression that all sexual workers are victims, and they're exploited, and these are not his words; they are my words. We need to save you guys. These are my words. Is that correct? Is that a correct impression?
I'd say, personally, we don't need to be saved. I don't need to be saved, and all my friends that are in the sex work industry don't need to be saved. They make decisions. Sometimes they wish things were different, that they could call 911 when needed, because right now it's simply seen as being, the dangers and risk are simply seen as being part of the work, and it's not. And the bill C-36 won't help on that, because then our clients are deemed criminals. And so basically what the bill says, if we call 911, is the police is going to say, well, you invited a criminal in your bed, and so they're not going to help us more. That's the help we need, is to have law enforcement on our side, not because if you criminalize part of it, then law enforcement won't be able to be on our side. They're just going to be trying to track down our clients, and even those are sweet, because in my experience, my female clients are just sweet women, and I know from talking to my friends that they have a lot of male clients that are just sweet. They're the sweetest thing you can find. They wouldn't hurt a fly, and they're always asking if everything is okay. It's not that 100% of the time. And that's when it's incorrect, that when we want to press charge, that we need to have a backup. We need to be able to go to the police and they treat our cases the same as they treat any other cases. And that's not the case, and with Bill C-36, it's not going to be the case either. We're just going to have to suck it up. And it's not going to change. We're going to still be anxious about what we do. Like has been said, if they are criminals, then we'll have to go underground and have a lesser contact with them to be able to determine if they are good clients or not. Not being able to advertise correctly also is going to undermine this, because we're not going to be able to have as good a contact. It's going to be difficult to maintain our, let's say, a trail of emails and see what kind of client it is and make a decision on whether we want to see that person or not. It's just not helpful. We don't need saving. What we need is to be part of society, just like everybody else, have law enforcement on our side, and be able to, because there's already somebody who perpetrates an aggression or a rape is already a criminal. We don't need it to be stated in any other way, certainly not in a way that englobes just about everybody and people that are quite innocent and sweet.
If I could just add on to that, I think Maxime brought up a lot of the same points that I wanted to bring, and I think it's important to remember that these laws that are being proposed and these things, everything is so broad, and the industry is huge, and there's so many different people who work in it, so many different people who use this service as well as clients, and to put it all into one basket like this has these effects on people, and it's generalizing, and it's not working. And I think as far as for male sex workers who have been left out of this discussion very often, it can be because male sex workers don't fit the ideal image of a victim. And I think that's important to bring up as well, that when people are pushing these laws and putting this certain thing forward, they have an idea already in their head of what they want to sell and what they want. And I think that often male sex workers are pushed aside because it's true, they don't fit into that, and their needs are different. Their interactions with their clients are different. Everything about how they work is different. There are similarities, yes, but it is so broad. There are different people, different profiles of people, different contexts of work. It is all so large. And so to bring it in and to use these words like everyone is a victim and everyone is like this and everyone works like that is just not relevant, unfortunately. Like, it does not work. For what we see, I work with street-based sex workers a lot, but we also work with other sex workers in other industries, escorts, dancers, massage parlors, and they're all so different, very unique people, and so it won't work to put it all into one thing like this, and these laws can cause these problems in that sense. So.
I would just
Oh, sorry. Senator Platt.
Thank you, Chair. Ms. Spooner, is there a difference between a body rub parlor and a massage parlor? Is that the same thing?
It's the same thing.
It's the same thing?
Yes, our attendants are actually body rub attendants. That is what is on their license.
Okay. Do your body rub parlors sell sexual services?
No, they do not.
So what's the problem then? If they do not sell sexual services, it's not illegal to get a massage.
Exactly. However, again, the Justice Minister has stated in his own comments, and it is in the government's own papers, that body rub parlors are being targeted under this legislation. What kind of impact it will have, we do not yet know. It may be up to the courts to decide how to read the legislation. But all I know right now that our clients are scared to patronize us once this bill passes. Our fear is that business will slow down. It will no longer be feasible for businesses like myself to stay in business, and our girls are not going to give up their livelihood. All they will do is go work independently, and unlike this bill suggests, they are not going to hire bodyguards. They're going to be working out of condos. Condo buildings will be saturated with girls working as massage attendants in their own homes, away close to schools, close to residential areas, which is not the case with our businesses. We are zoned the way we are structured. We are regulated and have been for the past 20 years.
It's certainly not my place or my intent to argue with you or debate with you, but I would think that for myself, I would feel more comfortable going to a massage parlor after this law was in place, because I would feel I was going into a legitimate massage parlor and get a massage, as opposed to at this point when I don't know for sure what I'm going into and what will be the chances of somebody standing there with a cell phone and taking a picture of me going into what
Well, correct.
legitimately I want to have a massage.
Correct, and I hope that that is the case, and I hope that many of our clients feel like you do. However, we are here today because we have been named in this legislation, specifically body rub parlors and strip clubs have been targeted in this legislation. So that is why we are
Again,
here
a
today.
strong difference between massage parlors and strip clubs.
Yes, absolutely. Just like there is between male escorts and female escorts, we are adult entertainment industry. I don't even refer to us as a sex industry. Not that there's anything wrong with the sex industry. We're all in it together, and we all want the same things. But I do like to make the distinction that the people who work for me are not prostitutes. They are body rub attendants, and that is
That's not entertainment, then.
It's
That's not
entertainment.
entertainment. You said you were in entertainment industry. That's not entertainment.
Oh, well, our clients think we're quite entertaining.
Thank you.
Thanks. Senator Joyal.
Monsieur le Président, welcome. Bienvenue, Monsieur Durocher. This bill is premised on the assumption that offering sexual services is exploitative of the person, whatever the context. It is the first paragraph of the preamble of this bill, and as the minister has said and his officer have said here 2 days ago, this is the philosophical basis for the whole of the structure of this bill. But from what I hear from you, doesn't seem that the person you are, of the of that activity, who perform that activities, have been pushing it because of all kinds of factors that would have put them into an exploitative situation. Can you comment on this?
Yes, absolutely. The thing is, this bill, like you said, is intended to stop trafficking and basically wanting to equate prostitution with trafficking. The two are very different. Personally, and I think a lot of my compatriots would support amendments to this bill. The two proposed by Mrs. Spooner, the one that would say that if you are targeting clients and saying that purchasing is illegal, we would like it to be amended to purchasing being criminal if the person is underage or if the person is being coerced. Those two things, I don't know why we need second, and this bill particularly to do that, but if they were amended to those two things, to restrict the criminality.
Parlez en français, Monsieur Durocher.
It doesn't change much. Just looking for my words, so. To restrict those two, restrict basically the being a crime to purchase sex from a minor or from somebody who's coerced. The same thing would be illegal to have a, let's say, a massage parlor or any agency that would have underage people or coerced people that were, so it would be illegal to have those two. So maybe agencies would get more, would pay attention more to the people they're hiring, and maybe the purchaser also would look at more into the age of the person that provides it. But those would be very important to clarify that they are restricted to those two things we actually want to abolish. Is basically because I'm against that too. If let's say if a minor came to see me, somebody who's even close to being close to 20. I would ask for IDs. Basically, I would do the same thing as in Quebec, la SAQ does for when somebody wants to purchase. If they come close to being 23, they ask, even if 18 is the law, automatically they try to, and I would do the same because I'm against minors being in the industry. I'm also against being coerced into the industry. I'm doing this on my free will, and this should be how it works.
And Mr. McGarry?
Yeah, very similar in the sense where when we're talking about that, these are things, yes, that there needs to be protection for these people who are being exploited, minors who are working in the industry. But again, like we were saying, the industry is very large, and the laws for those situations are going to be very different than what goes on between two consenting adults later on, people who do choose to get into this industry. They're very two different things, and those laws should exist. It's just this law that's being proposed throws everyone into the same barrel, and that doesn't work. Yeah. It criminalizes the entire act around it, whether you're 51 years old or whether you're younger, you know, and so I think that's what's important to bring out of this, that they're two very different things, and like Maxime said, there should be things in place to protect people who are being exploited, who are being forced into things, who are underage, all that kind of thing, but they're different, and that needs to be looked at separately. Again, like in these things, it's very complex, and it can't be all thrown into one thing where it's all summed up together, because that doesn't work, and then some people will face repercussions for it while other people gain, and it won't work, and so it needs to be separated and dealt with, Leon. So.
We have time for another. Mr. Atchison, in your research, have you ever paid attention to that aspect of the bill, which is the victimization of the bill? As I said, the first paragraph is about exploitative, inherent exploitative. Those are the words of the bill. And of course, the corollary that if it is exploitative, there is a victim there. Have you ever made any evaluation of what is the perception of the persons who are involved in the offering the sexual services as victim? Is it part of the psychology of somebody or is it something that might happen in certain circumstances? We have been told poverty and so on. But generally, in terms of your research, what kind of conclusion can we draw from your own studies in that?
From what I've paid particular attention to that over the past 8 years. I've been very interested in trying to understand how power works and the dynamics of power and when abuses of power occur, and awareness of abuses of power. And what I can say on the basis of the people that I've observed and that I've come in contact with is that there is no demand for coerced bodies. The simple fact that comes through the interviews that I've done, the surveys, that somebody might be doing this against their will, at a very sort of crass level, takes away the enjoyment of the interaction that the person purchasing sexual services is having. Only a complete psychopath would enjoy having sex with somebody who is bound and gagged and crying and clearly there against their will. And that, not only has that, I've never come across a single person in an interview or a survey that said that that's what they get off on. For that matter, when I ask people about their preferences, when I ask people and dig deeper to get into issues around what it is that they're looking for, what it is that they want to get out of this, a lot of it comes down to a need for some sort of connection at an emotional level, at a level of intimacy. Now, if somebody that you are with is there by force, and they aren't going to be capable of making that type of connection. Now, on a second issue related to that.
To get into the second issue, we'll move on to Senator Dagenet.
Thank you, Mr. Chair. Thank you to our witnesses. My question will be for Ms. Spooner. Ms. Spooner, I listened to you very closely. As a former cop, I have a little trouble with the image that you're trying to project of your business. I don't believe what you say. I don't believe you when you say you don't know what goes on behind closed doors. I don't know. We're before a tribunal. I know we're not before a court, but sincerely, would you be surprised if a body rub attendant told you, especially considering that you might they give them training on what to say to cops and what to say to you eventually. Would you have anything to say about that?
Girls are offering full service?
C'est que lorsque...
No. What I'm saying is, you say that people work legitimately and freely in your business and you don't know what goes on behind closed doors. I'm telling you that as a former cop, you'd be surprised perhaps to know that former massage parlor attendants, when they're hired, often get a training about what to say to the client and eventually what to say to the cops. I'm talking to you as a former cop. There's a lot of training given to the girls about what to say when they're asked for explications. There's, if you want, a formatted speech for that, and you haven't talked about that at all in your
Our girls on what to tell police. We have, on many occasions, have police come in and interviewed our staff. What the police who have come in, their main focus has been on ensuring that the girls are there of their own free will and are not being coerced, and to make sure that there was no drugs or alcohol on the premises and that there was everyone there was legal to work. All of our doors have peepholes on the doors as part of the bylaw. And police can come in, bylaw enforcement come in at any time and take a look through those peepholes to see what's going on. The doors are never locked. It is against the bylaw to have the doors locked. Now, I am not so naive as to think that it's beyond possibility for two adults in a room to engage in an activity that I wouldn't approve of. But all I can tell you is that I train my staff and I only hire girls who are only comfortable performing full-body erotic massage, not full service. And I trust in my staff, and if ever I do find out that someone is performing services above and beyond what we are comfortable offering, I do let that individual go. I have fired girls in the past, and again, I don't want to imply that there's anything wrong with prostitution. It's just that I know the massage parlor business. I'm not in the brothel business. So I conduct my business as a massage parlor. So our girls are comfortable offering those services. And again, through a thorough interview, I make sure I hire girls only comfortable offering full-body erotic massage. And if I knew that someone were offering extra services, I would let them go, because many of our customers who come into our business come there for many reasons. But the majority of them who come there because they know that no matter what, it's a safe environment, the girls are there of their own free will, and there are no additional services offered. It's good, clean fun. That's how they see it, as good, clean fun. It's about as good a clean of fun as you're going to have in this industry.
Merci, Madame.
Thank you.
Thank you. Senator McIntyre.
First of all, thank you for your presentations. I have two quick questions. My first question is directed to Mr. Atchison. Mr. Atchison, in your summary of the legislation, you make reference to the $20 million in new federal funding. As you rightfully pointed out, the emphasis will be on funding programs that will help individuals exit prostitution. I note that you support this initiative regardless of the exiting intent. However, you add on page 7 of your summary, and I quote, "The vast majority of those we surveyed are not in this situation," meaning the exiting intent. Could you just elaborate briefly on that, please?
Well, this notion of exiting is an interesting one. We don't apply it to any other industry or any other occupation. I mean, we don't have exiting strategies for police or politicians, who desperately want to get out of police work or politics. And that, when we approach investigating people working in the industry, my colleague Dr. Benoit looked extensively at, well, what is it that people are needing? And another colleague of mine, Ms. Raven Bowen, did research specifically in this area, which I counseled on, which is about this transitioning in and out of the industry. Quite often, people drift back and forth through this industry. It's not this notion of I'm here today, gone tomorrow. It's I can be here today, I can come back a month from now. So there can be temporary work in this area. And from what I understand, and from what I know of people providing frontline services to individuals who are involved in the sex industry, the greatest need isn't about exiting. It's about help with poverty, help with child care, help with other issues that are more pertinent in their life than exiting.
I could chime in on that.
Yes.
Just as someone who does work frontline work with sex workers, full-time, 3.5 years at this organization now, I can echo what he's saying. That is true, that the issues of what people are dealing with, it's rare that it is exiting. In the work I do help people leave the sex industry if that's their choice, if that's what they want. I can help them do that. If people want to stay in and work safer, if people want to leave at some point, but it's not realistic right now because they need to have a place to live first, they need to have access to health services first, all sorts of things. So I think the idea of just putting this exit strategy for everyone isn't going to work because everyone is at different places and they need to determine where they're at themselves. And sometimes there's really basic needs that need to be met first. And some of those basic needs are just respect and being treated as an individual and being able to go and have access to medical care, to be able to go and find a home and not get looked down on, be able to go and have child care and be able to do what you need to do. And I think looking at like what he was saying, it's not realistic to imagine that everyone wants to exit and exit programs are the answer because that's not reality for people, and it's not meeting people where they're at. The people who are working right now, that's not meeting them where they're at, and it's not realistic of everyone in the industry either.
Yeah, well, I think the emphasis of the $20 million will be on people to exit, but there are other programs, other community programs, okay, to help street workers. My other question, very quickly, Bill C-36 contains 49 clauses, and the House of Commons Justice Committee proposed an amendment to Clause 45. The proposal in the amended Clause 45.1 is to review Bill C-36 amendments to the Code after 5 years. And very briefly, could I have your thoughts on this, please?
5 years is a long time because if, as it is, legal process are going to be put in places, it's going to be fought right off because it's going to hinder our ability to earn a living. So in 5 years, we might have already gone to at least one court system, and in 10 years' time, we'll be at the Supreme Court. 7 to 10 years, we'll be back at the Supreme Court. So 5 years is too long, and we already have research around the world that have presented how unbeneficial it is. There's many places where, like in Sweden, there's research that I've seen that making clients criminals has actually been detrimental to and has never ever been able to
Some
stand
people have told us that they agree with the 5 years because we have to give time for the legislation to sink in, you know. So that's one argument. Okay, thank you.
Senator From.
Mr. Atchison, did you have the opportunity to hear any of the testimony before this committee yesterday?
Yes.
You did? Oh, you did. So you heard from Cassandra Diamond and Bridget Perrier and Larissa Crack and Diane Matt. You heard their testimony?
Yes.
And you still say you are unfamiliar with the interest in coerced sexual activity?
No, I don't say that I'm unfamiliar with it. What I do say...
You're right. You said there's no demand for it.
What I do say is among the people that I have conducted research with,
they say they're not
there is no discernible demand for that. And among the hundreds of hours of observation in various communities, I have not detected any support within the communities of people purchasing sexual services that encourages that. As a matter of fact, it's quite the opposite. There's a normative fabric within many of these communities where people gather to communicate that sex with people underage is not approved of. It's shunned within the community. Acts of violence and aggression are shunned within the community.
I don't know what that means. I don't know what you're talking about.
What it means is when discussion forums full of people who are involved in the sex industry form online, and they communicate about their experiences in the industry. If somebody steps forward and says, I'm looking to have sex with somebody underage, the entire community comes down on that individual and says, that's unacceptable.
And that's how it's done?
That's
if
how
I want to
it's
have
done.
sex with somebody underage, I tell the community that's what I want?
No, what it shows is that a large section of the community do not accept that as appropriate behavior, that there are people out there that definitely have those types of desires in any population, regardless. And within this particular population, they're as much of an anomaly as in any other population. And I would also...
You said there's no demand for it.
Well, I would also extend one thing. To make a distinction between somebody who is a client and somebody who is out to violently abuse. It seems that the two are getting very conflated. People who are out to rape and murder are not clients. They are not people who are interested in adult consensual sexual services.
Well, as you said in your presentation, we haven't had a good definition of violence. And rape and murder obviously qualify. But there's a wide spectrum of violence. And as we heard also from our witnesses yesterday, putting out a cigarette, pulling your hair, all kinds of other things I don't need to list that are, very violent things, or words. Words can be very violent. Insulting language, violent language. So violence... Pardon me?
If I may step in, I've been in contact a lot with different groups. And first of all, we're talking about sexual activities between consenting adults. I don't know if you're aware of it, but some adults like BDSM activities. And you cannot judge somebody for its behavior, its sexual behavior between two consenting adults. Violence is, as you define it, is not consenting. And anybody who does something like that, we have blacklists. We blacklist our clients that shows any kind of violence, that rip off the condom before penetration, or are just suspicious. We have our blacklists. We don't consider those as clients, and they are the minority.
Okay, but...
May I say something as
Sure.
well? Just on that, I think what you're bringing up, where you're talking about this violence that, people can face, pulling hair, cigarette burns, people being raped, stuff like that. This is something that can happen to anyone. It doesn't just happen to sex workers, it happens to anyone, and these laws exist for people. And so making these other laws created for sex workers is making them be like, well, you aren't like these other people. You aren't like, but they should fall into the same category. If someone is raped, whether it's a sex worker or anyone, they should have a right for that not to happen and stuff like that. And these laws exist already. Laws against violence exist, protection, stuff like that exists. And so these laws that are coming in are making it that this choice someone makes is putting themselves into this risk. So it's kind of like their fault that this is happening. But that's not true. These laws exist already. If someone does get raped, there is repercussions for that. There can be. These things exist. And separating them dehumanizes sex workers and doesn't make them doesn't make them feel like they fit in with the rest of society. The same laws don't apply to them, but they should. And they should be applied to them.
I don't think it's treating someone in a degrading way during sex. I don't think that law exists. So that law gets covered by this bill.
Thank you. We're going into a second round, starting with Senator Baker.
Well, I found the conversation very, very interesting. And I'm wondering, Mr. DeRoche, as a sex worker, there are some sex workers who are male. And of course, they have clients who are female. I mean, is there widespread violence that you encounter from women, or do you encounter any violence from your women clients?
From my client, this is a personal, I've never encountered violence. What we tend to encounter is something different. It's more like psychological violence. In terms that sometimes the client, if, let's say the client is not in the best possible state, let's say she had a few drinks, and then at some point she flips out because she just feels uncomfortable, unsafe or anything, and then she has a panic attack. And then we sort of have to deal with that. It puts a lot of stress, and she can cry out and be really upset. So we face more psychological violence than physical violence. And, we try to deal with this calmly and to the best of our capabilities to help bring back the client to a calmer state, so exit the date.
There are very popular television shows that are watched in Canada, in this country, by a great many people, that are reality shows of male, they call them gigolos on the program.
There's one is called Gigolo, another one is called Hung.
Yeah, these are reality shows that Canadians watch. And the clients are women. Now, that's a reality shows that are very popular with Canadians, ordinary Canadians. How prevalent is the practice of women who hire male, if you call them gigolos or prostitutes? How prevalent is that in Canadian society? And how prevalent do you think it is in American society? In the
I think
States?
American society or Canadian society, or I think Occidentals by and large, it's not extremely prevalent. It's not really in the mind share of most women that, we offer that kind of services, that it is possible, unlike the mind share of male, whereas it's as old as time that, if they want, they can have services for a fee. It's not as prevalent, but women have been exploring their sexuality more and more as years go by. They made extreme advance, for the right to vote at the early 20th century. The equality in pay is getting there. Women are getting stronger and stronger in our society, and they're seeing that their sexuality should be the equal of the man's sexuality, because in our society often we say men are very strong sexual beings, and we should be there, and it's our due to explore. Whereas women are shown as more sexy, but not sexual. They should be sexy, but they shouldn't be sexual. And now there's a counterbalance to that. Slowly, it's coming back to be more equal on that level. And of course, there's always the whole rhetoric that if a woman wants to have sex, all she has to do is go to a bar and pick up a guy. But more and more women are realizing that strategy in itself is not a very good one, because the guy in the bar would probably think about his own satisfaction first, and the end result will probably not be very satisfactory. And that's why a professional service is more satisfactory.
This bill will really crack down on these women.
Oh, yeah.
This bill will put these women in jail.
Oh, yeah.
We've seen a large increase in females and couples seeking out our services in recent years. So it is females also, along with their husbands, that are also seeking our services.
Supplementary from Mr. Durocher. You operate on your own. You're not part of a business. How important is advertising to you with respect to attracting clients?
It's very important because I need to expose myself, my personality online, and actually women don't, by the way, women don't like to have explicit pictures. It turns them off. But still, I need to present my personality, not as, because most female escorts will usually offer their services directly, and men will come and answer their ads. But for female, I need to be out there, to have a Twitter account, forums I participate in. So basically, I need to engage them in other manners which are non-sexual, which is just presenting my personality and showing them that I'm there. So I need to be able to be out there on the web so that they can find me and see what kind of person I am. Then they'll take the time. Usually they can take months sometimes to decide who they find interesting, if the gentleman will fit what they want to encounter. So it's very important to me and to a lot of people in the industry, because it helps us make better connections. Because if you have access to a wider spectrum of potential clients, then you can filter out those you don't want. Basically, often it's when you get weird wording in the email and you get like, I'm not too sure I want to see that person, and say, I'm sorry, but I don't feel comfortable. And then you turn and you go to the next one. But the narrower the field is, the less the number of demands you get, you'll jump to more icky situation, and you'll just feel downright disgusting sometimes giving services to certain clients. And of course, with the bill like C-36, is that you narrow it down to people who are not afraid of being criminals. What does that leave in? That those that are exactly criminals, those who would perform criminal acts like violence, rape, murder, those, they're already doing something criminal, so they don't care if if being a client is being criminal.
Senator Batters.
Thank you. Mr. Atchison, so just so I'm correct on this, I just want to get so you're a research associate with the Department of Sociology at the University of Victoria. So you're a sociologist.
Correct.
No legal training.
No.
Okay. I don't think you were able to get to this at the end of your opening statement. I was aware of it because a written copy of it was passed out to us, but at the end of your opening statement, you wanted to tell us that you recommend that this particular bill be sent to the Supreme Court of Canada for a reference, a review. Mm-hmm. Okay, I don't agree with that, and I'm just wondering if you were, I'm not sure if you heard this particular testimony yesterday. It was yesterday afternoon during the infamous particular panel, but also in that panel we had Ms. Bedford's lawyer sitting right beside her, and we had Professor Benedet. Both lawyers, both from completely opposite sides of the equation on this particular issue, yet when they were asked whether we should have a reference to the Supreme Court of Canada on this particular issue, both of them said that they did not think that we should have a reference, and they Ms. Bedford's lawyer, of course, was fairly junior, but Professor Benedet had 20 years of legal background on these exact types of issues. So would that surprise you that both of those lawyers had the completely same response on that particular point of view?
Wouldn't surprise me. My encouragement to send this to reference is to save needless suffering and countless amounts of money that the government is going to have to spend over the next 30 years, because it took 30 years of court challenges to have the current laws that were in question overturned. It could very well take another 30 years. And that means that the government is going to be spending millions and millions and millions of dollars for something that they could conceivably bypass by simply sending this to the Supreme Court for review.
Of course, in the meantime, if we don't have a law passed by mid-December, then we would have those particular provisions that the Supreme Court had suspended striking down would not be in place at all anymore. And we would have significant gaps in the prostitution law in Canada. So I just aren't you a little bit surprised the fact that Ms. Bedford's lawyer had that particular approach when you would expect her to perhaps have the same viewpoint as you did about this?
Perhaps, with different legal reasoning. But I also beg to disagree that, not putting forward the new laws doesn't leave significant gaps. We have existing laws in the criminal code to cover many of the instances of abuse. We have laws against murder. We have laws against rape. We have laws against assault in existence. We just need to actually have a space where they can be enforced. We need to have police that actually take the complaints of people involved in the sex industry seriously and respond to them and treat them like humans.
Okay. We'll move on to Senator Jaffer.
Mr. Atchison, I really appreciate the paper you've done and your point of view.
Here, here.
The one reason I appreciate it, and my colleagues will correct me if I'm wrong, is that we've heard from many different people from many different facets of this bill But the one group of people we haven't heard for obvious reasons is from people that you study, the clients. And when the minister spoke, when he testified here, he spoke about prostitution being illegal. I don't quite agree with him, but let's put that. And then he talked about giving immunity to the seller, but not to the purchaser. And I don't know if you've had discussions with people who purchase, and would you be able to share with us how they are reacting to this?
Well, at present, within all individuals in the sex industry, there's this climate of uncertainty that is contributing to a climate of fear. Because the fear of the unknown, what's going to happen next, in December or January? The conversations I've had with people who purchase sexual services, am I going to be a criminal, right? I've already been labeled a pervert by the minister, which probably accounts for why you don't see very many people who purchase sexual services wanting to step forward and testify, because they're already being shamed, shunned, and stigmatized. So it would be very surprising to see somebody walk in here and say, yeah, shame, shun, and stigmatize me more. When it comes to the law, fear of law, also my research has shown this, fear of law creates the very same conditions that I was speaking about earlier in terms of an unwillingness to be transparent and clear in communications. It causes people to be rushed. It causes people to want to hide their identities, which is a key safety mechanism for both sex workers and their clients. Open, knowing, okay, this is your number, this is where I can contact you. So this whole notion of the potential of them being criminalized, it's shaking them up. But moreover, what I find interesting is it's also causing many people to move advertisement offshore, out of Canada. So the very act that this is going to stop, no, people are already doing exactly what I would figure, the same thing that happened when we saw enforcement of street-level provisions. They're basically moving. They're moving, and it's displacing the activity. People are thinking, okay, how can I continue doing this? But still within a climate of fear.
Just as well as with the work that I do, I work very directly with clients as well. And I think that in the work I do, I work for sex workers, for their health, their well-being, and all that. And the health of their clients directly affects them as well. And we're looking at these laws, and I think that you brought up a good point about, these directions being rushed and this climate of fear, and no one can really be honest about what's going on when there needs to be honest discussions. If we're talking, too, about protection and about sexual education and safer sex use, then that's a discussion that needs to be had, and there needs to be a space for that to be had. Many of the clients who access male sex workers, many of the male clients who access male sex workers, as well, some of them, like I mentioned, can be going through a coming out process who aren't necessarily sure about their sexual identity, having these problems as well. And so maybe the health services they're accessing don't actually answer any of these questions that they need to know about safer sex practices between two men. And so they don't feel comfortable going to services for gay and bisexual men because they're not necessarily there. That's not where they're at, and maybe that's not how they identify, and that's okay as well. But there needs to be the access for them as well to have access to service for testing, for counseling, for their own health, and that does affect the health of the people around them, the people they work with, their families or other partners they have outside of their encounters with sex workers, all of that. And so criminalizing them or criminalizing the client, either way, these moments of no one can say what's going on, no one can have these discussions to talk about these things, to talk about health, to talk about safety. A lot of the discussion we've been having has been about violence towards people, but we're often leaving out things when we're talking about HIV rates, hepatitis C, STIs, and stuff like that as well. And this is something that needs to be addressed, and people need to be able to have these conversations, feel free to have access to condoms. Workers like myself need to be able to go out and speak with people and have a space where we can talk about this. We can accompany them to resources. We can accompany them to the services they need so they can feel secure, they can feel safe, and they can make good decisions. They can follow treatment plans if they're on treatment. They can get tested, all these things. So I think criminalizing either one will still create these environments where these conversations can't happen, and it limits access, not just like we're talking about violence, but also health. If we're looking at public health, we're looking at larger scale things with what's going on right now with all the advancements for the treatments of hepatitis C and HIV and how we can control these viruses and bring down transmission rates. A lot of it is through treatments, through testing, through counseling, and we need to be able to offer those services to people, and these laws will further push that away and close that. And I think that's something as well.
Thank you, Mr. Mayor. Mr. Atchison, you were interrupted in giving me your answer on the issue of victimization that I asked for you. So could you come back with the second part of your answer? If you remember what we were discussing earlier on?
Absolutely. The other thing that I wanted to get at was on this issue around victimization, clients play a very important potential role in reporting abuses. Quite often, people who are purchasing sexual services are in a position to witness potential things going on. They go into an establishment and see, this doesn't seem right. That there's something, these people don't seem, the worker that was presented to me doesn't seem like she's there by her own free will and volition. All due respect, in those situations where these are run by unscrupulous individuals, it's not the managers and owners that are going to report that. And as we've heard from numerous testimony, quite often that particular individual providing the services isn't in a position to do so. But the client is. And one of the things that my recent research shows is the willingness of clients to do this.
And if I may, I have another question for Mr. McGarry. Mr. McGarry, you're a street worker. Yes. So I would understand that you certainly have encountered police presence on the street.
Yes.
In the area you might be working.
Mm-hmm.
What is your perception of what the police will do now that they will have the responsibility, according to this bill, to chase the customer?
Well, I think what they will do exactly, I don't know, but I think that when it comes to the effects it will have on the people, it will still be very similar to what's going on right now. When we're doing sweeps like this, we see the effect it has on neighborhoods, on people, making people, feel less safe, not have the moment to discuss, be more incarcerated, coming in and out of the prison system, not get the support they need. And I think whatever they end up doing now, if it comes to really like striking down on street-based sex work and the clients and whatever, it will still have the same effects, that there will still be, like these issues where people will be coming in and out of prisons, will be dealing with incarceration, not getting support, not being heard, and it will just keep driving things more and more underground instead of having people feel like they have a space where they can discuss what's really going on, issues, problems, and bring stuff forward. I'm not sure if that answered your question.
No, it does. Okay. Partly, Mr. Atchison, the preamble of the bill wish to that people who are involved in the sex trade will want to report incidents of violence and to leave prostitution. That's the last to one preamble of the bill. In other words, the objective of this legislation, if we try to understand all the objective of the legislation, one of the key elements, if you want to reduce prostitution, because that's the objective, stated objective of the bill, the police forces as a primary role to exercise, to assume. It seems to me that when we look into the practicality of the bill, in fact, it will do the reverse. It will produce the reverse situation. It will more push the person who offers sexual services outside the police ambit. In other words, they don't want to encounter the police because they feel that they're going to be, at the end of it, caught into the justice system. What is your perception of, or your evaluation of the bill in relation to that objective of the bill?
Well, I agree with that contention completely. I think that what this bill does, I don't, like say that pushes it, I don't say it pushes it underground, which we've heard. What it does is it pushes it out of view, pushes the people's interactions out of our view, and makes it increasingly impossible to detect where things are going wrong, where people are experiencing some forms of victimization. As I said before, when you label people, if you're labeling clients as criminals, and then we've heard de facto prostitution is illegal. So de facto, you're also saying that the people who provide those sexual services are party to a criminal act. So they're also criminal by proxy. These people, it just creates a climate of mistrust. Why then would anybody in their right mind believe that somebody's going to turn to the police and say, yes, I now trust you to report this? that doesn't seem realistic to me. When it comes from the vantage point of clients who, again, could report these things and also experience their own forms of victimization, they're going to be even less likely to report those types of instances. And then basically what we have is this kind of where things are, how things get resolved is at a street level. And I don't personally am not very comfortable with people resolving things with street justice. And I don't think anybody would be. I mean, that equates to violence.
Thank you. And the final questioner, Senator Platt.
Chair, Mr. Atchison, part of the preamble also says, where it is important to protect human dignity and the quality of all Canadians by discouraging prostitution, which has a disproportionate impact on women and children. You have been emphatic here on saying that you haven't been able to, Senator Fromm asked you, Senator Batters asked you, you have not been able to find out where people actually want to be violent. We heard, as Senator Fromm suggested, she gave you names. We had a lady here yesterday who said that at the age of 15, she had to have 15 stitches in her cervix. She could not have children because of the way she had been abused. We have heard over and over and over about this. And then you sit here and you somehow self-righteously say that we shouldn't be calling those people perverts. We haven't called one person around this table a pervert, nor have we heard any of the other sex workers present here this week that we have called perverts. I don't believe they are. I believe they are trying to eke out a living. These two men right here are trying to make a living. I haven't called them a pervert. Robert Pickton is a pervert. He's a killer. And I won't apologize for calling him that. And for you to suggest that we should somehow call him something else, and for you to sit here and suggest that we don't have violence, continued violence, I find objectionable. Is this the way you usually conduct yourself when people disagree with your point of view?
The way I conduct myself when people disagree with my point of view, I listen to what they have to say. I acknowledge that there are truths in different accounts, that there are many different accounts of the sex industry, but I also acknowledge that it was Minister McKay who outrightly called all people who purchase sex perverts. He set the stage for that comment, not me.
And also...
No, I'm sorry. We've run out of time, and I want to thank you all for being here and offering your perspectives on this important piece of legislation. And members of the committee, just before we adjourn next week, we're hoping to Wednesday to conclude our pre-study of C-36. We're still in the process of firming up the appearance of a number of witnesses, but certainly that's the intent, to complete the pre-study next Wednesday and then move on to the tobacco legislation on Thursday. So, and further information to follow. Thank you very much. Meeting adjourned.